So we've just started our live streaming, and we're ready to begin our day's work today. To those who are watching on YouTube, this is the Joint Standing Committee on the Judiciary, and we have 4 public hearings on bills this morning, and then this afternoon we'll do a number of work sessions. And in between, we're going to sandwich a Freedom of Access Act review. So before we start this morning's bill hearings, I am going to call on committee members to introduce themselves. And let's see, Representative Libby, could you please begin?
I'd be happy to. I'm Laura Libby, and I represent District 64, which is part of Auburn and all of Minot. And if I go dark at some point, it's because I'm home with my kiddos on April vacation this week. So I'm zooming from home instead of Augusta, and they can be a little wild sometimes.
That
Good to
sounds
see your
fun.
face.
Representative Poirier.
Thank you, Madam Chair. My name is Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thanks. And Representative Thorne.
Good morning. Thank you, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Thank you. And Representative Hagan.
Thank you very much, Madam Chair. I'm David Hagan, House District 101, Hampden and Newburgh, and I've invaded Representative Jorgensen's territory in Island Falls for the week. It's beautiful and it's snowing like crazy here.
Wow. Thank you. Representative Evangelos.
Thank you, Senator. Good morning, everybody. Jeffrey Evangelos, House District 91. I represent 4 towns: Waldoboro, Washington Union, and Friendship. Thank you.
Thanks. Representative Newell. Oh. Oh, I think you're still muted.
Did I do that incorrectly?
We can hear you now. Go ahead.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I am the Passamaquoddy Tribal Representative. Thank you.
Representative Sheehan.
Thank you, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent the good people of Biddeford's House District 12.
Thanks. And Representative Moriarty.
Thank you, Madam Chair. Good morning, all. Unlike in Hampden, it's sunny where I am. Happy Administrative Professionals Day to everyone. I'm Steve Moriarty from District 45, Cumberland, and part of Gray.
Thank you. And Representative Babbage.
Good morning. My name is Christopher Babbage. I am a resident of Kennebunk, and I have the good fortune of representing House District 8. And for the record, unlike Island Falls, it's 56 and very sunny here. We have an amazing geographic reach on this committee.
And co-chair, Representative Harnett.
Good morning, Senator Carney, and welcome to everyone. My name is Tom Harnett. I represent House District 83, which includes the city of Gardner, where I live, and the town of Farmingdale. Nice to see everyone.
And Senator Sanborn has just joined us. Would you like to introduce yourself?
Sure. Thank you, Senator Carney. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook, and apparently timed my entrance just right this morning.
You did. Thank you, everyone. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And let's see. So before we begin our public hearings today, I just want to let members of the public know, as committee members already know, that the public hearings are our opportunity to hear from members of the public and bill sponsors weighing in on legislation that comes before our committee. And we'll be asking questions of those folks. We will reserve our debating on the bills for when they are scheduled for a work session. We'll have a work session on some other bills this afternoon, and these bills that we hear today will come up for work session within the next week or so. And with that, we will begin our first public hearing on LD. And I just want to check in, with my co-chair, Representative Harnett. We did not have any special requests for folks to go first. Is that right?
That is correct.
Okay, I have missed that previously. So we'll begin our public hearing with LD 864. And I am going to bring the bill sponsor over. The bill sponsor is Representative Dodge, and she's going to be joining the panel momentarily. Welcome, Representative Dodge. It's nice to see you this morning. We have heard weather reports from many members of our committee. You're welcome to give one. We've got everything from warm, sunny days to snow, and you can proceed with your bill whenever you're ready.
Thank you very much. Good morning, committee. The weather here in Belfast is very pleasant, and I'd say just a tad cloudy, but the sun is peeking through and it is wonderful. Thanks. Good morning, Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. I am Representative Jan Dodge of House District 97, which includes Belfast, Northport, and Waldo. I am here to present LD 864, an act to protect teachers' privacy while delivering remote instruction. Parents have always been encouraged to get involved in their children's education. This includes visiting classrooms, viewing materials, and checking out the curriculum. Parents, however, are not allowed to take videos or recordings of teachers when classes are held in person, and this same policy should apply while instruction is provided remotely. LD 864 prohibits a person from making any audio, video, or digital recording of remote instruction and prohibits them from accessing, viewing, listening to, disrupting, or otherwise participating in remote instruction for elementary or secondary school students. During my years as a music teacher, I taught a New England unit in my music appreciation class. It included the poetry of Robert Frost, a video of the history of the lumbering industry, art of Winslow Homer and Andrew Wyeth, sea shanties, and readings from Moby Dick. A choir singing the doxology was part of the soundtrack of one of the videos. One of my students said they sang that at their church after the offering. Another student asked about the religious reference to the number 3 that was mentioned in the video. And there I was, explaining the Trinity concept in Christianity as my principal walked into my class. This is one instance where if a parent could record and post a video clip from this class, they could very easily portray the exchange out of context. I was not attempting to convert anyone. We were simply learning about historical New England culture and religious influences. Another example would be our discussion and activities surrounding the Salem witch trials. But there are hundreds of lessons that are taught every day in American schools that could be construed incorrectly. Students need to be able to discover and ask questions. Teachers need to encourage deep thinking and feel safe answering those questions, free of fear that something could be taken out of context. Please pass LD 864 to extend the in-person privacy protections already in place for teachers delivering remote instruction. Thank you. I will try to answer any questions you might have.
Thank you very much, Representative Dodge, and also thank you for your weather report.
You're welcome.
We appreciate you being here to explain this important legislation, and I see that there are a couple of questions already. Representative Libby, go ahead.
Practices to support those in their care. LD 663.
Thank you so much, Madam Chair, and thank you for being here today, Representative, excuse me, Representative Dodge. A couple questions. The first one is that I had received a message from someone who was concerned about this bill and had asked if this bill would be intended to prevent parents from spending time sitting with their kids during Zoom lessons. And I guess my question about that is that in various districts in Maine, the failure rates of students have been reported as very high this year. And given the modality, the very different modality of education, and that there are upwards of 20% of kids failing any given class, I would think that sitting in and even recording to be able to review later these lessons would be encouraged nowadays rather than banned. So can you speak to that, please?
Certainly, thank you. Good morning. I appreciate your question. This bill does not prevent parents from sitting with their children and helping them access their instruction. But again, there have been instances, I believe some of the folks who will follow with testimony will explain that there have been situations where parts of lessons have been recorded and then rebroadcast in forums with inflammatory comments. That's the protection that is intended with this bill. As far as recording the lessons, I hear what you're saying, but again, I think it's important to strike a balance, and this bill is intending to provide that balance.
A follow-up, Madam Chair?
Yes, go ahead.
Thank you. So I do wonder, I appreciate the goal of this being teachers' privacy. I wonder if you had any thought about students' privacy. There have been many news stories. A Maryland school had police search a boy's home after a BB gun was spotted in his bedroom. A Louisiana fourth grader was suspended for having a BB gun shown in his bedroom during virtual lesson. New Jersey School District had police call.
Representative Libby, I think this
Yes.
bill is actually about teacher privacy and remote instruction.
I understand that, but I wonder if there's a place for student privacy as well. So that's what I'm trying to address with the sponsor.
Yeah, I think that would probably be a different bill that would go before the Education Committee. You can answer it if you're able to, Representative Dodge.
Well, I think that we already, in many instances, you can see that teacher privacy is in some instances related to teacher privacy, particularly if you're delivering hybrid instruction. And students need to be protected as well. And I'm sure that you have seen on the news and in many forums where a student's face is blurred so that they can't be identified. So I do think there is a concern about student privacy as well, but that is not what is being addressed in this bill.
Thank you, Representative.
You're welcome.
Representative Hagan, your hand had been up, but it's down now. So let me know if you have a question.
Yep. I do. I just wanted
Great.
to let other people go first. So if Representative Babbage would like to go first.
No, why don't you go ahead because you were next.
Okay. Well, thank you very much, Madam Chair. Just a quick one. So this would, according to state law, ban anybody from having the ability to hit record like I have a MacBook Air right now. I couldn't record on this. Would it prohibit recordings made by telephone, my camera, taking a picture of the classroom teacher, and then using this against them down the road? That would be my question.
I would defer to someone with more legal expertise than I have, but I would refer you to the bill where it does go into a bit of detail about audio, video recording.
Okay.
I believe it's lines 19 and 20.
Thank you. I'm sure I missed it. I'll check it. Thank you.
Thank you.
Representative Babbage?
Thank you, Madam Chair, and welcome, Representative Dodge. Good to see you again.
Good to see you.
Yeah, I have just a couple questions. It seems to me, having spent 40 years in the classroom, I very much appreciate what this bill, hadn't even thought about this in depth, and I appreciate you have, that you have. It seems to me that what is being protected is the student-teacher interaction. And I appreciate that. So to me, the protection of preventing unauthorized access is a protection of both students and teachers, don't you think? That would be number one. And then secondly, I'm asking if somebody did want to record a certain lesson, couldn't that be done with permission? So I guess the second part of this would be, what makes a person authorized if unauthorized people are prohibited? Thank you.
Thank you for that question. And I do believe that you probably would be able to record a lesson if you felt that, long division instructions were being given and you wanted to record the lesson. I don't think the technicality of the discovering that had happened would come to fruition unless you misused that recording or in some way. And I agree, we are talking a bit about the teacher-student interaction as a big part of this. Does that answer your question?
Does. So in actuality, it would be the misuse that would trigger a penalty.
I do not have a degree in law, although I have said a couple of times, boy, by the time I finish my second term, maybe I'll have half a law degree, but I wouldn't be able to answer that. I'm sorry, I'm not sure.
Speaker Rowe once told me that each term is equal to a master's degree. So that's good.
Representative Moriarty, go ahead with your question, please.
Thank you, Madam Chair. Good morning, Representative Dodge. Good to see you. It's been a while since I had kids in school, and so I'm a little rusty about this sort of thing. But you mentioned that parents have the right to personally attend classes in normal times and observe and so forth. But I think, did you say that they could not record or videotape a classroom session in person?
Again, that's one of those technical loophole kinds of questions that someone who testifies after me, I think, will better be able to clarify that. But again, it would be my understanding that the example I gave about long division, if you know your child is not good in math, you want to record the long division lesson, again, I think that certainly is possible and fine. But as Representative Babbage pointed out, were you to misuse something that happened in that lesson or share identification of other students in a remote situation, I think that's when people would realize that you had perhaps used that in an incorrect way. But again, I defer to those with legal expertise.
Okay, thanks. I've got some more questions about remote education, but I'll save them for those who will follow.
Thank you.
Thanks very much.
Representative Poirier?
Thank you, Madam Chair. My question is more the enforceability of such a law. How can you stop somebody from recording, particularly in like a Zoom situation, even if you were to disable like a record function of a Zoom? People have cell phones and those sorts of things can't be controlled from the outside. So the enforceability of this sort of law would concern me because there are outside things that you just can't control. Do you have any insight on that whatsoever?
Thank you for that question. And again, I don't think that there would be a problem about someone making a recording or the need for enforcement until there is misuse of a recording that has been made. So I don't, I'm perhaps not looking at it through the correct lens or the lens that you are looking at it through. Does that help?
Somewhat, thank you.
You're welcome.
Representative Thorne?
Thank you, Madam Chair. Welcome, Representative Dodge. Thank you for presenting this bill. And full disclosure, my wife is a teacher of 28 years, elementary school, and she just recently switched to pre-K. So that goes a long ways in helping her deal with me. I just read the second paragraph in the summary that says this bill also prohibits a person from making any audio, video, digital recording of a real-time transmission and so forth and so on. And somehow I'm getting my terms mixed up about public, it being public, and not being able to be videotaped. In other words, I think we just saw this, a parallel, I guess, would be the way that they videotape police. You know, that's a public setting and it's a public profession. And there's no restrictions on that. And I'm split both ways because I can't even go in the room when my wife is Zooming or teaching a class when she does it remotely. So she's very protective of the students' rights, even from me, somebody she thinks pretty highly of. So I guess that's where I'm at, is I'm trying to differentiate in my mind between the public word of a classroom and prohibited from someone viewing. And it says in the first one, prohibits from accessing, viewing, listening to, you know, just I'm trying to differentiate where those two lines are drawn.
I will try to be, I will try to use utmost care as I answer, again, because I am not a lawyer. There will probably be people after me who can better explain this. But after 30 years in the classroom, I believe that I was protected from people listening at my doorway, peering through my window, and that parents could not come into my classroom and make a video recording or an audio recording. I believe that is current practice and I believe law, but again, we need that clarification. So this bill, I believe, is merely trying to transfer that protection for teachers and students. And as far as the public, yes, what teachers do, we teach in a public school, but our classrooms are not public. They are not open to the public on a daily basis for people to wander in and out willy-nilly. Even parents will usually, unless it's just some, hi, I'm here to pick up my child, can I just sit through these last 5 minutes of your lesson? Usually say, may I come to visit your classroom for this art session or for this particular event? Does that help clarify a bit?
A bit, and I'll listen to the following presenters that testify, but it's still, I'm trying to differentiate between why we, you know, the public aspect of it and I guess refusal of admittance, you know, what would constitute that, but that's a discussion for another day. So thank you very much. Thank you, Madam Chair.
You're welcome. Thank you.
Thank you. And just to clarify, Representative Dodge, this legislation would apply in both the public school setting and a private school setting? Looks like that's at the very end of paragraph 3.
Yes,
That recording is prohibited unless there's express written consent by the public or private school.
yes.
Okay, thanks. Representative Harnett, you had a question?
I did, and thank you, Madam Chair, and nice to see you, Representative Dodge.
Nice to see you.
Following up on Representative Thorne's question and some of the testimony you delivered, you seem to indicate it's not a problem having a parent or guardian helping the student with the course instruction, watching the course instruction, and even, I think you said, if it was a lesson on long division, to tape the instruction so they could go back to it to learn more. But under the bill as currently drafted, that would be illegal. That would be illegal to make a copy or to record anything that is going on. And it seems, as I understand it, what you're most concerned about is not the recording of the event, but the subsequent dissemination of the event, to distribute it or to transmit it. And I'm curious if you had thought about an amendment that would limit it to those specific acts, the distribution and retransmission, because that seems to be the issue that you're trying to address. Is that something you would think about in terms of an amendment moving forward?
Absolutely, and I had thought of that, but again, this is the committee where you have way more knowledge than I about this sort of thing. And so I would defer to you and to the reactions and information of those who will follow me with their testimony and their expertise also.
Thank you very much, Representative Dodge.
You're welcome, Representative Harnett. Nice to see you.
Senator Sanborn?
Thank you, Madam Chair. Ms. Dodge, Representative Dodge, excuse me, I thought that your example that you gave at the beginning of your testimony was really resonated with me. I was a world history teacher as well and had some of those same conversations in my classroom. Isn't the distinction here really that when a parent is in your classroom, you're going to know that they're there? Whereas in the or if any visitor, the press is in your classroom, you're going to know that they're there, versus if we're in a virtual situation, you have no idea who your audience is beyond your students. And I think that is the distinction. And I was wondering if you see that as a really sort of a bright line, that it's important to know who you're talking to as a teacher, because some of those conversations where you're answering someone's questions could be taken out of context if they're edited and disseminated into a video clip in the future.
That is absolutely the situation. If my principal or someone had pulled out that discussion about the Trinity, I had folks who were very, in my community, who were very concerned about the crossing of the line of religion and instruction in the classroom. So I was always very careful. And when my principal stepped in, I didn't miss a beat. You don't change what you're teaching, but again, it's that, could they take 3 or 4 sentences of that, broadcast it, republish it, make a few hinting comments. And Ms. Dodge is teaching religion and trying to, save my child. And so that's where I'm coming from.
Representative Babbage?
Thank you, Madam Chair. Yes, to follow up on Senator Sanborn, I think this bill is trying to address the issue of classroom privacy in an electronic age. And, I wanted to ask you about 2 things. One being the, if I compile my 15 best lessons I can publish that and gain monetary benefit from that. If I use it in school, using school resources and so forth, I think the school can also claim part of proprietary ownership of those lessons. So, I'm wondering if that's not a part of this as far as videoing and dissemination. So that's one question I had. The other, I guess, was I think it was just about the authorization and necessary. I guess what I'm asking is the intent of this bill to prohibit malicious intent in the use of video recording or whatever?
Yes, that is the goal of the bill. And I hadn't thought about the proprietariness of lessons delivered. That's another whole issue, and that's not what I'm driving at. It's the malicious rebroadcasting of something a teacher says. Yes.
Thank you.
Thank you.
Looks like there are no more committee questions, so thank you very much, Representative Dodge. You can stay on the panel while we bring in others who are speaking with regard to the bill. And at this point, I'm going to turn to the attendee space. Anyone who is here to speak in favor of this legislation, please raise your electronic hand and keep it raised.
Thank you very much, committee. Thank you, Madam Chair, Mr. Chair.
You're welcome. We have one proponent who is joining us on the panel.
Good morning.
Good morning. Welcome to the Judiciary Committee, Ms. Levitt, and you can begin your testimony whenever you're ready.
Thank you very much, Senator Carney, Representative Harnett, and esteemed members of the Committee on Judiciary. My name is Grace Levitt. I am a Spanish teacher on leave from Greeley High School while serving as president of the Maine Education Association. The MEA has nearly 24,000 members, faculty, staff in our pre-K-12 public schools, institutions of higher education, and many dedicated educators. I'm speaking on behalf of our members in support of LD 864. This bill is vitally important for our teachers to be able to continue to provide remote instruction to Maine students during this pandemic and possibly for some time to come. Before March 2020, I doubt that anyone would have envisioned needing such legislation. But here we are, over a year later, and pretty early on in the current school year, it became apparent that the provisions called for in LD 864 are essential. This is what the bill does. It provides some level of protection from the following happening: a part of a proper, carefully planned lesson, part of an established curriculum, part of an open and balanced discussion is recorded, taken out of context, shared, and displayed on social media, where a teacher or possibly a student is criticized, ridiculed, even threatened by others who not only do not have knowledge of the fuller context, but may also be out to undermine the teacher, the school, or even public education due to their own personal beliefs. This bill also provides some level of protection from someone who is not the intended audience of the lesson, i.e. someone who's not a student in the class, from interrupting and disrupting the lesson, thereby impacting not only all of the students in the class and their right to learn, but also undermining the teacher and even potentially damaging the relationship among classmates and the established class climate. This is what the bill does not do. It does not say that parents should not know what is being taught. It does not say that parents should not know what is happening in their child's school. And it does not say that parents or guardians or other caregivers cannot assist a child with remote instruction. It does not say that a member of a household is prohibited from incidentally listening to or viewing a lesson. And it does not say that others are prohibited from accessing the class if they have permission to do so. The objections raised by those opposed to this bill demonstrate that they've not maybe actually read the language in the bill. They also indicate that they are unaware of a very serious incident that happened early on this school year. The scenario described above actually happened. A parent recorded a part of a lesson, which was part of an established curriculum. The parent shared it on social media, maligned the teacher, the school, others joined in, and actually threatened the teacher. Threatened the teacher. We've had reports of a household member intentionally interrupting and disrupting a classroom. I'm not referring to an unintentional or minor disruption like someone talking to another person in the background or just accidentally walking behind a student and appearing on camera, but an intentional disruption where the person speaks directly to the teacher and or to other students.
Ms. Levitt, the 3 minutes has passed. If you could just wrap up your testimony.
Well, I would just say that when we're in person, the school would not allow just anyone to walk into a classroom without permission, especially now with security being a concern, or to disrupt a class. If permission is granted, and I had to have permission when I had to record classes for obtaining my national board certification, I had to have express permission for that from parents and from the school. And so that can be done when it's in person.
Thank you, Ms. Levitt.
Thank you.
Let's see if committee members have some questions for you. Committee members, are there questions for Ms. Levitt? I am not seeing any questions. Thank you. Oh, yes, we do have one. Representative Moriarty, go ahead.
Thank you, Madam Chair. Good morning, Ms. Levitt.
Good morning.
When a student is at home participating in a class that's being broadcast, is that student's image seen on screen in a way that can be recorded by someone else?
So right now, I suppose I could be recording this screen, take a screenshot of your committee hearing. And that is what a classroom looks like from the person viewing it at home, unless they have their video off. But I'm sure teachers would like to see the students' faces and know that they're engaged and be able to see if they're understanding. And so they are expected in schools to have their video cameras on. So yes, the answer would be yes.
Well, I'm just a little unclear. When a lesson is underway, is the camera focused exclusively upon the instructor or upon both the class members and the instructor as well?
So it depends on the setup that different classrooms have and where the camera is. I know that in some cases it is focused on the teacher, but if there's any sort of movement around the classroom, there are likely to be other students. I thought you were referring to the students who are connecting remotely, if they were showing on the screen. So you're talking about the students that are still in person when it's a hybrid situation.
I did mean those who are at home watching. Can they be photographed or recorded on tape?
Yes, I believe they could be, just as your hearing is being recorded now as well. And so you would be seen in that recording. Maybe I'm not understanding the question, but hopefully I'm answering it.
Okay, I just, never having seen a remote class, I'm just not sure what one observes and whether the camera moves about and broadcasts different people's images from time to time, that sort of thing.
And in some settings, the students that are in person may also be seen by those who are connecting remotely at home, although primarily it's focused on the teacher, but depending upon what the classroom setup is and what the subject may be, it could be different.
Okay, that's good. Thank you.
Committee members, additional questions for Ms. Levitt? I'm not seeing any. Thank you very much for joining our meeting today.
Thank you.
And I'm going to move you back to the attendee space. And now I'm turning to those who are in the attendee space and asking if there's anyone else wishing to speak in favor of LD 868. Again, not seeing anyone. Is there anyone wishing to speak in opposition to 868? Please raise your electronic hand. So we have Judith Meyer, and I am going to bring you onto the panel, Ms. Meyer, and hopefully she'll appear momentarily.
Thank you,
Welcome.
Senator Carney.
Welcome to the Judiciary Committee, and you can begin speaking whenever you're ready.
Thank you, Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Judy Meyer. I'm a member of the Maine Press Association, which represents 43 daily and weekly Maine newspapers. I'm here in opposition to specifically to paragraph 3 of this bill. This bill is something of a bookend, LD 331, which was an act to prevent or to protect student privacy, which came before you in February. And we are opposing paragraph 3 of this bill for the same reasons we came before you in February. We take no position on any other portion of LD 864. Paragraph 3 of this bill would make it illegal to make any audio, video, or digital recording of any class in any public or private school without the express written consent of the school. As we noted in February, under pandemic conditions, students have heard presentations from astronauts, from politicians talking about climate change, from artists and authors sharing their craft. Our teachers have done a remarkable work in creating learning environments in a world of remote education, much of which was conducted using real-time transmissions and was recorded. In-classroom learning is something that the media has traditionally been invited to cover that could, under this proposal, end. There are so many great things happening in our schools, and not only is it media's role to report on that, but it is important for our communities to know and understand what students are learning, how they're learning it, who they're learning it from. Great teachers whose valuable lessons would be shut away from public view under this proposal. Additionally, it creates an extreme burden on schools to issue express written consent to every media outlet that requests access to recorded classroom instruction, or that requests to make its own recording of a classroom instruction during real-time transmission. It would be a vastly more complicated process than is currently in place, and one that could potentially curtail the public's understanding about what goes on in Maine classrooms. Maine's Freedom of Access Act holds that recordings are public records, and the Maine Press Association asks that you maintain access to recorded classroom instruction. Thank you, and I'm happy to answer any questions you may have.
Thank you very much, Ms. Meyer. Committee members, are there questions? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Ms. Meyer, if during normal times the media could attend a classroom session with permission, how difficult was it then to get such permission?
It would be a matter of a simple phone call. And often, you know, teachers will reach out to us. So it's kind of a two-way street.
Okay. The paragraph 3 closes with the words that express written consent of the public or private school basically eliminates the prohibition. Why would that be an extreme burden as compared to the pre-pandemic context?
Well, let's take the example of Senator King talking with public high school students about climate change this year. It was only a couple of months ago. He spoke with multiple students and teachers in multiple high schools across the state. I think every broadcaster recorded that and reported on it. All of Maine's daily newspapers reported on that. The weekly newspapers surrounding the high schools that were involved reported on that. So we're talking about dozens, perhaps even hundreds if every school was to be contacted to get express written consent for an event like that. An event that I would argue the public would be intensely interested in hearing, not just from a sitting senator, but from the students and teachers involved in that conversation.
I'll ask one more question if I may. Is it your position that conventional in-person classroom instruction is a public event, for want of a better term?
That is not my position. But once it becomes a recording, Maine's FOA specifically notes that all recordings of any kind are public records. So if this bill were to move forward, there have to be some distinction made here. Maine's FOA may even have to be amended to make this exception. And the idea that it makes it illegal for media to rebroadcast something that we may be recording would also, I think, have to be expressly noted in the bill.
Thank you.
Representative Babbage?
Thank you. Thank you very much, Madam Chair. Good to see Ms. Meyer again.
Thank you.
It does seem to me that you're bringing up that recordings of any kind are a public record is an endorsement of why they would want to prohibit recordings of teacher-student interactions without permission. I mean, I would ask you what the process is right now as far as the press access to the classroom. I mean, if you're going to come in and listen to a presentation, I remember in 1974, maybe 75, no, it was 74, the fall, I had new Representative Bill Cohen in my classroom. And Watergate had just, the resignation had just happened. But my point is, if the press were there, would taking notes on what is observed is one thing, but having a visual which would represent minors that could be reproduced, aren't there restrictions on that right now without express permission?
Right now, if we were to go into a classroom, an in-person classroom, well, let me back up. At the beginning of every school year, schools send out notes to parents asking for permission for the media to photograph them during in-classroom instruction. Parents may sign the permission slip, which means it's good for the entire year. If they don't sign the permission slip, if the media were to go into a classroom, those children would be moved to the side. We would be informed who is not permitted to be photographed. And we then have permission to photograph and record video and audio, everything else that happens in the classroom, teachers, special guests, all other children without restriction.
Thank you.
Representative Harnett?
Thank you, Madam Chair. And these may be questions that are directed at our analyst for the work session. I understand that. But Ms. Meyer, I agree with you that recordings held by public entities are subject to FOA, typically unless there is an exception in the law. What I'm not certain is, are all classes recorded by the school as opposed to simply transmitted by the school? And as to Representative Babbage's point about somebody filming something at home, that doesn't make it a public record because that person is not a public entity subject to FOA. So if these classes are not being recorded, they're simply being transmitted, does that resolve your concern about a recording being withheld in violation of FOA?
It would resolve my concern about a recording. It would not resolve the concern about the media being able to take a video itself of that classroom instruction.
Okay, thank you. And I'll follow up on these at the work session, and I appreciate your input.
Committee members, are there any additional questions? Not seeing any. Thank you very much for joining us today.
Thank you very much.
And then I believe that we have one person who signed up in advance to speak neither for nor against, and that's Victoria Wallach. And I will bring her over to the panel. Representative Libby, did you have a question?
Thank you. I just wanted to note that I've had 2 folks reach out and request that I read their testimony against aloud, as they were not able to be here today. So I'm willing to do that at whatever you think is the appropriate time.
I think that they should submit their testimony
It is
in writing, and
it's submitted in writing, but there is a provision that states that if they request, and I'm happy to look that up, that if they request it be read aloud by a legislator, that is allowed.
Yeah, if you could look that up for me. I'm very cognizant of the time and the fact that there are probably about 35 or 40 people who submitted testimony in writing. And if we were to read through all of them today, we would still be here tomorrow.
I do understand that. Fortunately, only 2 reached out and asked me to read theirs aloud.
Well, let's hear from our live witness, Miss Victoria Wallach. And welcome to the Judiciary Committee, and you can proceed.
Thank you. Good morning, everyone. Senator Carney, Representative Harnett, and members of the Judiciary Committee. I am Victoria Wallach, Communications and Government Relations Director for Maine School Management, testifying on behalf of the legislative committees of the Maine School Boards Association and Maine School Superintendents Association, neither for nor against LD 864. Our associations appreciate what we believe is the intent of this bill, which is to protect teachers and students from any harassment or derision by members of the public who view a class conducted on Zoom or other platforms. It also hopes to protect against so-called Zoom bombing, where someone gains access to the Zoom and posts inappropriate material. Several incidents occurred around this issue. I'm sure there are more than I know of. Several I read about in the Bangor Daily News. In one instance, a student's parent recorded part of a lesson on social equity for students who could be marginalized. The parent posted the recorded lesson on social media by sharing it with a political social media group. It generated hateful comments toward the educator. In another instance, a student who was not a member of the Zoom class got access and displayed nudity. We find these incidents reprehensible and would not hesitate to take action and contact authorities if necessary, if they rose to a level where physical harm was being threatened. Our concern is with the definition of authorized person and the fact this bill would have school districts be the authorizers, which means our leaders, our superintendents and principals. In truth, we do not have control, nor we have the capacity to investigate who is appropriate to be with a student during a remote lesson. We also question how feasible it is to prohibit anyone from making a recording of a Zoom lesson. And I also wanted to respond, we don't feel that classrooms and the recording should be wide open for public dissemination by the media. And I'm a former journalist, so I always say this with my heart in my hand, but we have to protect kids first. So I would like very much some opportunity to weigh in, and maybe I can get some information together for you in the work session on what would be a reasonable precautionary method. The permission slips we use for photographs are usually like photographs that would be in the yearbook or a team sport, or it's not the notion that a photographer from a media outlet is going to come in and take a picture of a child in a classroom. We have control over that in the real world, and we would like control over it in Zoom. So I know my time is up. I'll be happy to take any questions.
Thank you very much. And thank you for offering to put some thought into finding more of a, for lack of a better word, middle ground, but a way to provide some protection for students. Committee members, are there questions for Ms. Wallach? Go ahead, Representative Babbage.
Thanks. Just a quick one, I hope. Thank you, Ms. Wallach, for being here. I appreciate it. I just wanted to push a little bit about, I'm not sure as I understand your concern about authorized, what's the word? Oh, authorized person as far.
Yeah.
Yeah. Because you do that in real time in school. Electronically, it seems like that would still be appropriate, enforceable or not. I mean, obviously, it's the misuse that we want to prohibit. But as far as authorized access, in or out of the electronic medium, it seems like it would be an appropriate request that you be authorized in order to participate.
And I'm looking at it from a practical standpoint. It's not going to be just the parent. It could be the babysitter one day. It could be a grandparent. It could be anybody that the parent has placed in charge of their child if they're at work. So is it possible? I think so, but I'm not sure it's going to offer the kind of protection that we were hoping for. Do you understand what I'm saying? That's where we were at.
Any additional questions, committee members? Not seeing any. Representative Libby, I wanted to check back in with you and see if you had found some indication that there's a rule allowing you to read into the testimony, into the read during a public hearing testimony that has already been submitted in writing to the committee.
I don't have it right here in front of me. It is common practice, and I will find it. It is common practice that when someone comes to the State House, which is currently not allowed, and has testimony that they want read into the record, that they can ask a legislator to read it aloud. And so that is essentially what I've been asked to do. So I'm not sure why it would be different during Zoom, that if someone requests that their testimony be read aloud, that would not be allowed, especially where it's 2 out of the many testimonies that have been submitted.
Yeah, and I would just say that I am not familiar with that being a common practice, and so I'm going to rule against your point of order at requesting to read that. I would like you, though, to please state for the record the 2 persons whose testimony that you wanted to read, so that it alerts us all to the fact that they did wish you to read it.
Thank you. One is Representative Justin Fecteau, who's currently in AFA and couldn't be here with us today, but wanted to be. And the other is Mark Chassie, a resident of Auburn, Maine, and my constituent that asked me to read his testimony aloud. Again, could not be here today.
Okay, I don't see their testimony.
I'm looking right at it in the portal with the schedule.
I might have to refresh my portal then. Thank you very much for pointing that out, and we appreciate you doing that. Committee members, I see some other hands up. Representative Babbage.
Thank you, ma'am. No, I don't need my hand up.
Representative Hagan.
Thank you, Madam Chair. I'm remembering more than one occasion where a representative was allowed to read a testimony in this committee, and I fail to understand why this simple request can't be made. Seems like a reasonable request. We have a representative who would like to be heard and has the platform of a representative in our committee. So it seems very reasonable to me that we would hear this verbally as opposed to, of course, we can read it. Sometimes it makes a big difference to hear it. So I think we should be able to hear both of them.
I appreciate you reiterating the position that you and Representative Libby have. We have a system where people can provide written testimony. They can sign up online to deliver testimony remotely. And those are the systems that we've developed for the way that we are conducting electronic hearings. And we need to do things the way they have been set up and proceed with our hearings so that we can complete our work both today and for this session. And having having a third option when people have available the other two options just doesn't seem appropriate to me. It's not accounted for in our rules. And again, given particularly this committee, the volume of work that we have to do and the need for us to move on, I'm going to rule those requests out of order and deny them. Representative Newell, did you wish to raise a point?
Thank you, Madam Chair. I am trying to locate the testimony that Representative Libby has mentioned. I've looked into areas so far, and I'm about to look into committee materials. Is that where it's at? Okay, thank you.
Thank you, Representative Newell. And with that, we'll bring the public hearing on LD 864 to a close and move on to our next bill. The public hearing on LD 1221 is now open, and we'll welcome the bill sponsor, Representative Harnett, to go ahead and present the bill.
Thank you, Madam Chair, and good morning to all. Before I begin the testimony, I'll be introducing three different bills today, so I'm going to skip the introductions as I get to the other two, but I do want to recognize the work of the Right to Know Advisory Committee because these bills came out of that committee and all were agreed to unanimously except for one, and I want to thank the committee for their work. With respect to LD 1221, good morning, Senator Carney.
Representative Harnett, I'm sorry to interrupt you. Your camera is off, and I don't know if you're doing that for, okay.
No, I had somebody come in to hand me something. Sorry about that.
Well, that's all right. Well, you can proceed.
Good morning, Senator Carney and fellow members of the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner. I'm here today to introduce LD 1221, an act to implement the recommendations of the Right to Know Advisory Committee concerning public records exceptions. Every year, the Right to Know Advisory Committee has a subcommittee that looks through all of the, or a portion of the exceptions to FOA, and they focus on certain chapters. In the 129th, this bill implements statutory changes recommended by the Right to Know Advisory Committee after reviewing certain existing public record exceptions in the main revised statutes titles 8 through 12. They take a series of chapters every year. This bill amends a provision relating to books, records, or correspondence produced in response to a summons in an antitrust investigation. It makes the language consistent with how other exceptions refer to documents that are not subject to disclosure, and clarifies that the confidentiality of the records is not tethered to an affirmative option of the person providing the records. It further clarifies that the books, records, or correspondence produced in response to a summons may be disclosed by the Attorney General with the consent of the producing party and in court pleadings or other papers filed in court. This bill also amends a provision relating to water well information collected by the Department of Agriculture, Conservation, and Forestry, Division of Geology, Natural Areas, and Coastal Resources, Maine Geological Survey. It removes the exception designating as confidential information collected by the Maine Geological Survey at the request of a well drilling companies to whom the information pertains if the division has determined it contains proprietary information. Those are the changes that were recommended by the subcommittee in those various titles, and they were approved by all members of the Right to Know Advisory Committee. I thank you for your attention and would be happy to answer any questions you might have.
Thank you, Representative Harnett. Committee members, are there questions for the bill sponsor? I am not seeing any questions for you, Representative Harnett, and I'm just going to check and see. I'm looking at the attendee space, and let me just see if anybody has signed up to testify on this bill.
Excuse me.
I'm not seeing anybody signed up to testify with regard to the bill, and I'll just ask Those who are in the attendee space, is anybody here to testify in support of 1221? Or in opposition? Neither for nor against? So in the absence of any other people signed up to testify and any committee questions, we'll bring the public hearing on LD 1221 to a close and open the public hearing on LD 1345.
45, okay.
Oh, were you planning to do
Well,
1436?
it doesn't make a difference. They were listed in a different order. Why don't we, I'll do whatever you want. Do you want me to go ahead?
You may choose. You are the bill sponsor. They're both your bills.
I have 1346 in front of me. Why don't we do 1346? And again, good morning, Senator Carney and fellow members of the Judiciary Committee. I am here today to introduce LD 1346, an act to implement the recommendations of the Right to Know Advisory Committee concerning fees charged for responding to public record requests. This bill implements recommendations of the Right to Know Advisory Committee concerning the fees that an agency or official may charge to cover the costs of responding to public record requests. The bill does the following. It extends the time period for which an agency or official may not charge a fee for searching for, retrieving, and compiling a requested public record from the first hour of staff time per request to the first 2 hours of staff time per request. It also increases the fee that may be charged for the first 2 hours of staff, after the first 2 hours of staff time per request, for searching for, retrieving, and compiling a requested public record from not more than $15 an hour to not more than $25 an hour. Lastly, it specifies that an agency may retain any fee or cost that it charges in their own funds. I will point out, you will be hearing testimony from others on this bill, including a member of the Right to Know Advisory Committee. This was approved by a majority of members. I believe the vote was 12-1. I'm not sure of the exact total, but there is a member of the committee who opposed it, and you will hear from her. It's my belief that this bill recognizes years of work done by the committee and was a compromise amongst many, and was only arrived at after polling municipalities and state offices throughout the state. And we determined that most requests are answered or satisfied within 2 hours, so that most people will never be charged for the time spent in having an agency respond to their request under the Freedom of Access Act. With that, I thank you for your attention and would be happy to answer any questions you might have.
Committee members, are there questions for Representative Harnett? Not seeing any right away, but I had a couple of questions for you,
Sure.
Representative. So do agencies have to charge, or does this authorize them to charge within the parameters of the statute?
That's a good question. It's my understanding that municipalities may have some flexibility, but I think agencies that they're in their discretion can provide the information without charging. What this is trying to address are large scale requests for information, oftentimes by commercial interests, but not always, requesting volumes and volumes of information that requires an agency, a state agency, or a municipality to expend sometimes hundreds and even thousands of hours in meeting the request. That's what it is designed to allow them to have that ability to charge for those services once the request is over 2 hours, although I do not believe that they have to do so.
And a follow-up, and so currently the status quo is that the hourly rate is capped at $15 an hour and it kicks in after the first hour of research. And what this would do is change it to a $25 an hour cap that kicks in after 2 hours of research.
That is correct.
Thank you. Thank you for answering my questions. I see that Representative Moriarty has a question.
Yes, thank you, Madam Chair. Representative Harnett, is the term agency intended to refer to a division of the executive branch of state government, or does it include cities and towns across the state?
It includes all state entities covered by the Freedom of Access law, which would include municipalities, cities, towns, etc.
So that's how the term is defined in the right to know law.
That is correct.
Okay, good. Thank you.
Representative Libby?
Thank you, Madam Chair. And if my device dies, I'm trying to get on another one. I am just wondering, it seems like this could be an impediment for larger requests and for Maine people having access to information. The reason that I have a question on this is that I recently helped a Maine resident do a freedom of access request related to the two portals, the snitch lines. And it turned up over 1,700 pages of data for that request. Now, the individual who did the request would have no way of knowing that that was the volume of data that was going to turn up. So I just am a little bit concerned about ramifications for Maine residents, wanting to get this information, but being impeded, if they don't know the volume that it's going to turn up. And then what happened? Do they not get the information if it's something that they can't afford to pay for? I'm wondering what the process is there and if this will be an impediment to Maine residents having the freedom of access.
Thank you very much for the question, Representative Libby. And I think your question touches more on the next bill that I'm going to introduce, which is the charge for the actual production of the records, the copying charges. This has to do with the number of hours it takes to find out what that information is. There is also a process by which the state agency or municipality can let the requester know this is going to produce X number of documents. You might want to consider that before having the agency go forward with that. If you're unable to, you don't want to make that expenditure. One of the genesis of this bill is that, and I'm going to focus on municipalities right now. Those large requests, somebody's got to pay for them. Somebody's got to pay for that staff time. And the question is, if you have a request that is taking, let's say 50 to 100 hours, should the property taxpayers of that municipality be footing that bill, or should it be the individual seeking to have that work done? That's what it is trying to address. As to the specific question about the portals that you were trying to assist your constituent with, I would be curious if the state agency got back to them and said, here's what we're going to be pulling up, and this is what it's going to cost. So it's a question of who's going to pay for that time spent. I don't know if that responds fully to your question. Could it be an impediment to some people? Perhaps it could. I don't want to deny that.
Thank you.
Representative Harnett, could you please give us an example of, you were referring to commercial entities that were requesting voluminous information from municipalities. Can you give us an example of what you heard when the Right to Know Advisory Committee was working on this issue?
Yes, and the Right to Know Advisory Committee did work with the Maine Municipal Association to reach out to as many municipalities as possible. I don't recall all of the examples. I do recall some very large requests regarding GPS data that municipalities may have regarding all of the property in that municipality that could be used by sometimes realtors and other people that make commercial gain by having that type of data. And some of those requests could take hundreds of hours, which for a small municipality, and having served as a mayor of a very small city, I can tell you that that can place quite a burden on a municipal budget, a small municipal budget. So it was those types of requests. it's typically not residents of the community seeking information that they need about how their government is operating. It's not designed to impede transparency. It is simply to deal with larger requests that take a large amount of time. Somebody has to pay for that. And the question is it the property taxpayer or the person that is seeking and using that information, sometimes for personal gain?
Thank you.
And I, as we come to a work session on this, I will review the work of the Right to Know Advisory Committee and provide more examples at that time.
Thank you. Representative Babbage?
Thank you, Madam Chair. Yes, I'm okay. Representative Harnett, I appreciate you bringing this forward. I'm very appreciative of the 2-hour window. I grimace at fees being increased always, because I do feel it's an impediment. I understand the discouragement of data mining, companies taking up the time of agencies and so forth. But I think all agencies, even municipalities, see this as bothersome and would like to penalize people who are taking them away from their regular duties in order to scrutinize something that may show distrust on process or something. So I'm not concerned about data mining, the well-being of those companies. I am concerned about the press and the impact of a $25 fee on its bottom line, because I think the press is under duress. Was there any receptivity to an incremental increase, the third hour being 10 or 15 and then 25 from there on, or something like that? Well, I hate to have a 2-hour, 2-minute thing, I hate to have something extended in order to collect the fee. You see what I'm saying? Which can be exorbitant if you're a small periodical trying to find something to report to the people. Thank you.
Thank you for the question. And there was a lot in that question, and I'm going to try to cover all of it. Under current law, say you had a 3-hour, a request that took a municipality 3 hours to satisfy. The person would be charged $30 right now, because they would have the first hour for free and the next 2 hours would be at $15 per hour. Under the new law, if it were approved by this committee and the legislature, that same 3-hour block of work done would be compensated at less than $30. It would be $25. So the citizen would be paying less for that work under the new law. I do want to point out that the survey that was done by MMA, municipalities take their obligations, as does the state, as we heard from the ombudsman, under FOA very seriously. They don't want to block requests. They in fact want to comply with requests. The $15 an hour rate was set quite a while ago. It never compensated for the work being done by the municipal officials, and the cost of that work has gone up quite a bit since that time. The survey revealed that many municipalities are, when you start figuring in salary, benefits, et cetera, are spending far more than $25 an hour. So this is not, I don't see it as a money grab. I understand that, every time we increase something, we want to examine that, but that's not the intent of the bill, and that's not the response that we received from the municipalities and services and agencies that we surveyed.
Thanks for that answer. Thank you, Madam Chair.
Senator Keim, excuse me, go ahead with your question.
Thank you. Representative Harnett, I was wondering if it was explored at all, a difference between municipalities and state agencies. I understand, and as you know, served on the Right to Know Advisory Committee, and this has been a discussion for years. But and I understand the municipalities with smaller staff and the weight that they feel with some of this. I agree with Representative Libby and also Representative Babbage that we have to be careful we're not increasing the gate, right? Like raising it up so that people cannot get the access to the information. But I'm also concerned that the state doesn't necessarily have to have the same reimbursement as municipalities. Was that talked about?
That specifically was not addressed as far as I recall. What was addressed were various permutations and combinations depending on who the requester was. Was it from somebody out of state as opposed to in-state? Was it the press or not the press? Was it an academic institution doing research? After talking through all of those possibilities, this is where the Right to Know Advisory Committee ended up with one dissenting vote. The specific question, though, that your first question, I do not recall the issue being raised about drawing distinctions between state agencies and municipalities, but I will check that before the work session.
Great. And because I would love to know if that's something that you would consider, because I would like to further explore that. Thank you.
You're welcome.
Committee members, are there any additional questions for the bill sponsor? Not seeing any, so we'll turn to members of the public who wish to provide live testimony with regard to LD 1346. If you are in the attendee space and you wish to provide testimony in support of 1346, please raise your electronic hand. Not seeing anyone. If you're here to testify in opposition, please raise your electronic hand. And we have one person, Ms. Meyer, wishes to speak on this bill in opposition. And welcome back, Ms. Meyer. You can proceed with your testimony whenever you're ready.
Thank you, Senator Carney, Representative Harnett, and members of Judiciary. My name is Judy Meyer. I'm a longstanding member of the Right to Know Advisory Committee, and I am the dissenting vote. As Representative Harnett mentioned, this bill is a culmination of several years of debate about how Maine could better manage large FOA requests, specifically requests from data miners. These are for-profit companies that seek access to public records to create databases to reach new customers, for instance. The requests are enormous, they take a lot of staff time, and there's a general irritation about companies that use public records for their own profit. But this bill does not erase that problem. It probably doesn't ease the problem because these companies have proven time and again they're willing to pay, and they're willing to pay any price. So while this bill would certainly bring in more revenue for data mining requests, what it really does is punish Maine people whose interest in public records is personal. It punishes Maine's advocates and educators who access public records for research purposes. And most of all, it punishes the poor. A request for a 10-hour FOA request now costs $135. Under this proposal, it will be $200. A 20-hour request is now $285. It would become $450. A request that may take 30 hours to fulfill now costs $435. Under the proposal would cost $700. That would be enough to push poor people away and block access. And there's no question that the cost of public access is a barrier for all except those willing to pay any cost, like commercial requesters. Public records are created for and maintained in service of the public, and the public through its tax dollars pays for that creation and maintenance, and the public should not then bear a high cost for access to those documents. Maine's FOA does have a provision for an agency or official to waive cost, and there was a time when waivers were commonplace. That time appears to have passed, even when a request is made in the public interest. I do support Section 2 of this proposal, which allow agencies that fulfill FOA requests to retain their fees. Right now, any fees paid to fulfill FOA requests go into the general fund rather than to the agency that performed the work. So perhaps if this bill were to move forward with the current $15 per hour fee and all fees go to the agency fulfilling that request, that would be newfound money for that agency and maybe a balance to keep access fees down while ensuring the agency receives compensation for its work. Thank you, and I am happy to answer any questions.
Thank you very much, Ms. Meyer. Committee members, are there questions? Go ahead, Senator Kime.
Thank you. Nice to see you again, Ms. Meyer. Thank you for being here and for being the dissenting voice. I love that. I asked Representative Harnett an idea about making a difference between municipalities and state agencies. Do you have any thoughts around that, or is that something you could maybe give some thought to and share with us before the work session? Because I see a greater burden for municipalities, and I agree that this is an important effort on the part of government. Like, we have made the determination that transparency is important, and so therefore, what we figure is important, we have to put our money behind. But there is a different level of being able to absorb costs at the state level than at the municipal level. Any thoughts on that?
We talked about a lot of different kinds of tiers that could be set up, but this was not something that Right to Know talked about, and I think is worth thinking about.
Thank you.
Committee members, are there any other questions? I have a question for you. You mentioned just a moment ago that the committee had discussed a number of other tiers, so to speak, for allocating costs. And was there an alternative that you found more supportable from your perspective than the one proposed in this legislation?
Well, the tier that we talked about the most was where the request comes from, if it's from a Maine resident versus a data miner. The data miner, possibly could be charged more, which is how Pennsylvania's law works. But in Pennsylvania, that's kind of created this new job for Pennsylvania residents to submit FOA requests on behalf of for-profit data miners to keep the costs down. So people are able to trick the system. So all the tiers that we talked about, there were ways that people could manipulate how they work if they're divided by for-profit versus Maine residents, or nonprofits versus for-profits. And then of course, Maine's media, which is a for-profit with the exception of Maine Public, where does that fit in? If it goes in the for-profit category, if it gets its own category, and we really couldn't get consensus around that.
Yeah, thank you. Thanks for providing that additional information. Committee members, any other questions for Ms. Meyer? Not seeing any. Oh, Representative Babbage?
If I could ask Ms. Meyer, thank you, Madam Chair. Are there not constitutional issues with segregating treatment based on who you are in Pennsylvania? I mean, has there been any cases you know of?
I am not aware of any. The law was amended maybe 4 or 5 years ago. So I think if it was a constitutional challenge, it would have happened already. So I'm not aware of any.
Thank you.
Yep.
All right. And with that, we'll thank you once again for appearing before our committee today. And I think that leaves just one more person who has signed up to speak on this bill, and that's Kate Dufour, who I believe is neither for nor against. Representative Babbage, is your hand up for a question? No, okay, I just wanted to check in with you. Thanks. Welcome, Ms. Dufour, to the Judiciary Committee. We're happy to see you this morning, and you can proceed with your testimony whenever you're ready.
Thank you, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Kate Dufour, and I'm here on behalf of the Maine Municipal Association to provide testimony neither for nor against LD 1346. And in addition to delivering my testimony, my goal today is actually to actually be articulate. So hang on, I'm gonna give this a go. We are neither for nor against the bill because we do support the increase to $25 with respect to the hourly fee, but we do oppose the 2 hours of free. Our preference would be to increase to 25 and keep the rate at a 1 hour of free time. As Representative Harnett indicated, we did, at the request of the Right to Know Advisory Committee, poll our members with respect to those two particular questions. And the results of the survey are directly in line with what our policy committee advised. When it comes to the cost or the fee, that's the per hour fee that's paid, the survey results show that it costs communities on average $30 an hour. But the members of our members believe that we keep a balance between access to that data, which is incredibly important, as well as to recoup some of the costs that we expend, because if we cannot recover those costs, then those costs go on to the property taxpayers. So while the average rate was $30, our members thought maybe 26 would be more appropriate, which is basically in line with the 25 that's before you today. However, with respect to free time, the response from our members varied. In some cases, municipalities believe the 1 hour of free time works perfectly well. Others thought maybe it should be reduced to 30 minutes, while others think that communities should be provided the flexibility to decide, when a fee will be assessed. I mean, we've heard it throughout this hearing that there's a difference between, Molly coming in and asking for minutes of a board meeting and having us photocopy that for her, rather than a huge commercially related request. Or there are some individuals who engage in gotcha request, where a community will spend an awful lot of time generating materials. And the point we want to make is, again, this is like Representative Harnett mentioned, this is not a money grab, but it's just a recognition that your peers are also shifting burdens onto municipalities. Every time a decision is made, it's not made in a vacuum. And we feel the cumulative effects of all these changes. So the tax committee is extending another exemption. The environmental committee is issuing another mandate. So all these costs add up over time, and it's to the property taxpayers. So I thank you for your time and consideration.
Thank you very much, Ms. Dufour. Committee members, are there questions for Ms. Dufour? Go ahead, Representative Babbage.
Yeah, thank you. Hello, Mr. Dufour. Thank you for being with us. That's important for us to hear from you. Do you have, in your survey, do you have information as to the proportion of FOIA requests from individuals versus the press versus large volume people?
No, we didn't break it down that way, but I'll make sure you get a copy of the report. I'll send it to Peggy so that you guys can have a copy of that report. We didn't go into that detail, but if you look at the comments are very informative in this survey. They really paint a picture of the issues that are facing communities. And I think when you look at those comments, you'll see the municipal interest in ensuring that people get access to the records that they want. We're not trying to become a hurdle in that process. We're just trying to ensure that the reimbursement for that work is appropriate and doesn't further burden other taxpayers in the community.
All set, Representative Babbage? Senator Kime, go ahead.
Thank you. Thank you for being with us, Ms. Dufour. I was wondering, you said you're in support of Section 2 that I guess directs that the monies from these requests stay with the agency and don't go to the general fund, I guess. But where would the money be going in municipals? I mean, they wouldn't be sending it to the general fund from municipalities.
No, with respect to, we support the increase, so from 15 to 25. With respect to the revenue, I think that that specific notation is more directed at the state. The revenue we collect go into our own general fund and then are used. There are no strings attached to that revenue, so then it can be used to buy a new photocopy machine or do whatever it might be.
Okay, so I misunderstood then. I thought you had suggested that you were in favor of that part. So in actuality, the revenues do go into the municipality's general fund currently, and you're happy with that process?
Yes.
Thank you.
Representative Moriarty?
Thank you, Madam Chair. So, Ms. Dufour, I'm going to have to ask you what fee structure you would support. And I gather what you're endorsing is a free first hour, a second hour at the current rate of $15, and then $25 per hour after the second full hour.
Actually, our members would be one free hour and then $25 every.
Okay, thank you then.
Any other questions, committee members? I'm not seeing any, and I just want to confirm, well, first of all, thank you very much, Ms. Dufour, for appearing before the committee and speaking on this bill. And then I just want to confirm that all in the attendee space who wished to speak on LD 1346 have spoken. And it looks like that is the case. And so with that, we'll close the hearing on LD 1346 and move on to our last bill of the morning, which is LD 1345. And welcome back once again, Representative Harnett.
Thank you, Madam Chair. I feel like I never really went away. Good morning again, Senator Carney, members of the Judiciary Committee. For my third bill today, I am here to introduce LD 1345, an act to implement the recommendations of the Right to Know Advisory Committee. And I believe this addresses some of the concerns about transparency and cost that were raised when we were discussing the earlier bills and is designed to enhance those protections. This bill implements the recommendations of the Right to Know Advisory Committee that were contained in its 2020 annual report. You have the 2021 annual report attached in testimony today. This bill caps the fee to cover the cost of copying a public record. That's not set right now, and it caps it at no more than 10 cents per page for a standard 8.5 by 11 inches black and white copy. And it also clarifies that a per page copy fee may not be charged for records that are provided electronically. The bill also adds a member to the Right to Know Advisory Committee who has the legal or professional experience in the field of data and personal privacy. That position would be appointed by the governor. There was a great deal of concern raised over the last 2 years in the Right to Know Advisory Committee about the need to have somebody with that expertise regarding privacy. The bill also makes the following changes to the requirements for training under the Freedom of Access Act. It clarifies that an official must complete FOA training within 120 days of assuming the duties of the position. It also expands the list of municipal officials required to complete training to include code enforcement officers, town managers and administrators, and planning board members, and clarifies that deputies of municipal clerks, treasurers, managers or administrators, assessors, and code enforcement officers must also complete the training. Finally, it clarifies that school superintendents, assistant superintendents, and school board members are required to complete Freedom of Access law training, and this is designed to make sure that all officials that interact with members of the public seeking information regarding how government works and in order to increase transparency, have that training. And it's so that everyone who deals with the public in that way understands the municipality's responsibilities under the Freedom of Access laws, which would encourage more information being shared with members of the public. I thank you for your attention and would be happy to answer any questions that you might have.
Thank you very much, Representative Harnett. Committee members, are there questions for Representative Harnett? Representative Moriarty, your hand is up, and I'm not sure if it's from the prior bill.
My mistake.
Don't worry about it. Just want checking in. But Representative Babich, you can go ahead with your question.
Thank you. I should know this, Representative Harnett, but can you remind me what the time commitment is for a training and if it can be done remotely?
The time commitment is, I don't know exactly how long it is. I know I did it when I was the mayor, had to do it every year. It is under, I believe it's under 90 minutes, and it is something that can be done electronically.
Additional questions, committee members? I'm not seeing any, and so with that, we will move on to members of the public who wish to speak on LD 1345. And I'm turning to the attendee portion of the meeting. We have, is there anybody here who wishes to speak in support of 1345? Please raise your hand. In opposition of 1345, please raise your hand. And then finally, neither for nor against 1345. And we'll bring Ms. Dufour back into the panel to speak on 1345. Welcome back. It seems like it was just moments ago that we were together. You can proceed when you're ready with your testimony on 1345.
Great, thank you. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Kate Dufour, here on behalf of the Maine Municipal Association to provide testimony neither for nor against LD 1345. We support the elements of the bill pertaining to training. We think it's an important part of the process, and we are perfectly supportive of the expansion of the municipal officials who would be required to take this training. The training is rather simple. You can read it online, and the association provides that training as well. And I think it's posted on our website. So we fully support the proper education of individuals who are responsible for interpreting and complying with this law. We are a little concerned about the limits on the fees that can be assessed. Once something gets in statute, it's incredibly difficult to amend. It's there. And any attempts to try and modernize or update that data comes with accusations that municipalities are just trying to grab money. And so we're a little concerned with that. We're also concerned with the prohibition on assessing a fee for an electronic copy or a copy of an electronic record, because it's sometimes the case where communities will print those records in order to ensure the proper redaction of information. And again, our general concern is the inability to assess an appropriate user fee. When we can't do that, there are shifts. And again, it goes back to the property taxpayer. So I thank you for your time and consideration. Happy to answer any questions you might have.
Committee members, are there questions? I actually have one for you. It's about the redaction. So would the situation be that for example, a municipality might not have software that could be used to redact, and so they would print out a document, redact it by hand, and then scan it and transmit it electronically?
That's a possibility, but the example that was provided from a municipal official was reviewing hundreds of emails and just printing them off because it's much easier to work off the paper and redact as you go.
I see. Thank you. Representative Babich?
Yes, thank you, Madam Chair. Mr. Four, where does this, well, I guess current practice regarding an electronic response, electronic copy, of requested material. What about charging, and what's current practice regarding that?
I'm not certain. I assume it would vary from community to community, but I do not know what the practice is.
In other words, this bill provides that a per page charge may not be charged for an electronic copy. But I didn't know what I didn't know what current practice was. Can you tell me what current practice is for an electronic copy of a requested voter list?
That I honestly don't know.
That probably varies as well too then
I think there's a difference between asking for, a spreadsheet, and here's a spreadsheet of, revenue sharing, the amount of revenue sharing we've received for a decade. I mean, you can easily just zip that off, but if you're looking at emails and there's information in there that shouldn't be, that is prohibited to be delivered to the public, then you might want to take a little more time to just read that stuff. People work differently. There are people who are much younger than I am who can work directly on a screen, and there's those of us who are a little more old school that have to print things off in order to digest it. So that's basically the issue and concern.
Yeah, Madam Chair, if I can just follow, my line of thinking is when we had only printed voter list, I'm going back a ways here, 25 years, then to get a Portland voters list could be a gigantic amount of money comparatively to a little voters list you get from a small municipality. When we went to electronics, it was a dilemma because they only had a voter list charge, and so you got a disc from Portland, and it still cost you $100, $200, whatever it was, and so that's evolved over time so that electronic copies are now, I believe, much cheaper. And I wondered if that was relevant to electronic copies of FOA requests as far as the charging. But your answer is that probably varies municipality to municipality. Thank you. Okay.
And request to request.
Okay.
Representative Harnett?
If I might, Madam Chair, I'd like to respond to a question that you posed for Ms. Dufour. And she used the example of having to print out records so that confidential or otherwise non-discoverable or subject to FOA information is not provided. It would be my view that under this law, that would mean an electronic record is not available, and they would be able to charge the per page fee, because if they provided the electronic record, they might be disclosing information in violation of the law. So I would just point that out.
Thank you for clarifying and for answering my question. Appreciate that. Committee members, are there any additional questions for Ms. Dufour? I am not seeing any, and I believe that brings us to the end of the public hearing on LD 1345. So with that, we will close the hearing. Thank you all for your work this morning. And our schedule is such that we will be in recess until 1 o'clock, when we'll have a FOA review led by Representative Harnett, and then we'll begin our work session, list of work sessions at 1:30. And so if you are not signing out, please remember to deactivate your audio and video. See you all at 1. Thank you.
Hey, thanks.
Good afternoon, Jim.
Hello, everybody.
Hey.
Hey. I think we'll give it another minute or two for folks to rejoin us. All right, it looks like I think we have a quorum. Thank you for activating your camera, Representative Poirier. So let's get ready to resume. Wanted to let committee members and members of the public know what our schedule is this afternoon. At 1, right now, we're going to do a freedom of access review of legislation. And then we will start a series of work sessions on bills. We have 10 or so bills to do work sessions on. Work sessions are a time when the committee reviews the legislation and discusses it among ourselves. Sometimes we pull into our meeting people with information that we've requested in our public hearings in order to fill in the gaps that we had after the public hearings. But generally, we do not have public testimony at those. And so with that, let's start with our freedom of access review. And you look at the attendee list. And the review is on LD 541, an act to improve healthcare data analysis. And it comes to us from HCIFS, the Health Coverage Insurance and Financial Services Committee, which did the work on the bill. And Peggy, welcome.
Thank you. Yes, I am. I just emailed Senator Sanborn, and I'm hoping she's the representative from the Health Coverage Insurance and Financial Services Committee that is going to be helping you through this. And I have the YouTube of her committee up, and she is still in committee. So,
Peggy, can I just ask, is Dan Lawson the analyst for HCIFS? He's in the attendee space.
No, Colleen McCarthy-Reed is.
Okay.
Right.
Thanks.
So this bill is an act to improve healthcare data analysis, and it requires the thing that you need to be looking at is it requires the Department of Health and Human Services to report 2 things to the main health data organization. that currently are not being reported. One is cancer incidence registry, and the other is some vital statistics information. And so the idea of the Maine Health Data Organization is to collect a lot of information. Insurance companies, healthcare providers have to provide a whole lot of information to Maine Health Data Organization, which then does incredible analysis on trends and what's happening in Maine, and you can use that information to compare what's going on in other states. But because they get all this healthcare information, they have very strict rules of confidentiality. This is new information that would be in the hands of the Maine Health Data Organization. So rather than saying, oh, okay, their rules are going to cover it, the HCIFS committee said, okay, we're actually going to say in our amendment that this information that is now going to be in their hands, it's some of it is confidential in DHHS's hands, but now that it's going to be in the hands of the Maine Health Data Organization, we need it to continue that confidential status. And it's the personally identified information piece of that. And so if you have your packet, that information, that language in the committee amendment is on the bottom of page 10 in the packet. And if you need me to share a screen, I can do that if you give me a minute. And it says it's, so the data reported to the organization is becomes the organization's data and must be protected by privacy and security measures consistent with healthcare industry standards. The data is confidential and may be released only in accordance with the organization's rule on release of data to the public. And so the big bulk of this packet is their rules. Oh, and there's Senator Sanborn.
Good afternoon, friends. I'm sorry I was late. I've been chairing hearings and didn't realize that it had already become that late. If you, Peggy, can you give me the bill number?
Sure, it's LD 541 and 541, and I was already kind of explaining what your amendment does, how reporting that information to the Maine Health Data Organization about the cancer risk registry and vital statistics information, the personally identifying information, and the new language requires it to be kept confidential and consistent with their rules. And so that is a new provision that needs to be reviewed. I'm sure that you can be much more articulate and detailed and can answer questions.
Madam Chair, how would you like me to proceed?
I think it's fine for actually, I'm going to ask Representative Harnett is actually doing the Freedom of Access review. So I will ask you to direct your question to him. But I also have a question for the committee, which is, please let Peggy know if you would like screen sharing to see the particular provision that is at issue either now or at any point. And with that, I'll turn it over to Tom.
Thank you, Madam Chair. And Senator Sanborn, if you're comfortable, I'll just proceed with the review. And if I get anything wrong, you can jump in and let me know.
Sure, thank you. And again, I apologize for holding you guys up.
Sure. You know, sometimes I like to summarize things in the simplest way possible, but in essence, what we have here is the Department of Health and Human Services transferring information that is already confidential to the Maine Health Data Organization, and it needs to be kept confidential when it's in their possession as well. And the committee determined that the records need to be protected and collected because the work done by the Health Data Organization in terms of studying trends in cases of cancer, geographic trends, and recovery trends is important information to have for them to analyze and to further scientific research in the area of cancer prevention and treatment. So it needs to be collected and it needs to be maintained. The next question that we look at is whether federal law requires the record to be confidential. And in fact, HIPAA, the Federal Health Insurance Portability and Accountability Act of 1996 generally protects confidential, personally identifiable healthcare information. So this information is confidential under HIPAA. And then we need to answer questions: does the proposed exception meet one or more of the following? And I would focus on subparagraph D, which is whether the proposed exception protects an individual's privacy interest, and if so, whether that interest substantially outweighs the public interest in disclosure. And the information that's being transmitted, it contains extremely personal information that needs to be kept private, and it could identify persons who have are dealing with cancer or have in fact died from cancer. And there's no public interest in having that information received, made public, but there is great public interest in having these records to exist so that they can be analyzed to further the battle against cancer. So I would say it meets paragraph D. And also paragraph G, which is whether the public disclosure jeopardizes the safety of a member of the public or the public in general. And if so, whether that safety interest substantially outweighs the public interest in disclosure. And for the same reasons I just articulated, there's no reason for the public to see the personally identifiable information, but the information with that personal information stripped from it can be of great use to the public and academia moving forward. And in terms of balance, I believe this strikes the perfect balance, because all we are keeping confidential is personally identifiable health information, health treatment information, which is again arguably already made confidential by HIPAA. So we are keeping information that is confidential in the hands of DHHS, confidential after they transmit it to the main health data organization. So for those reasons, I'd open it up for questions, but I would support the conclusion reached by HCIF in terms of creating this confidentiality section. But I would be happy to have questions. I know I rushed through that fairly quickly. Senator Carney?
I just had a quick question for Senator Sanborn. Is there anything that you wanted to add, Senator Sanborn?
No, I would just note that the Department of Health and Human Services and the MHDO worked together with the Attorney General's office to kind of make sure that they could each be happy with each other's privacy policies in order to make this bill go. And then they did get to that place, but it actually took some negotiation because both of these agencies take the privacy of health data where it is personally identifiable quite seriously.
Okay, and Peggy, I know I ask this every time and I don't know why. Do we need a roll call vote on this?
I probably a roll call vote's good.
Okay, so the motion would be to approve or to recommend approve the confidentiality provision established in LD 541 at the request of the Joint Standing Committee on Health Coverage and Insurance and Financial Services. So that is my motion. I would look for a second.
Second.
By Senator Carney. Any discussion? Seeing none, I would ask the clerk to call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative, my apologies. Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Representative Newell. I will call the absentees again. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 are absent.
Thank you very much, Ms. Panett. And I will turn it back over to Senator Carney.
Thank you very much. Committee members, I wanted to bring a matter to your attention. We are going to move to reconsider LD 483, and this is out of consideration of a committee member who has asked to change his vote. And I apologize for not giving anybody a heads up. This came up a little bit suddenly this morning. So LD 483 is the Civil Legal Services Bill. And with that, I'll recognize Representative Harnett.
Thank you, Madam Chair. In order to lend a courtesy to a fellow committee member to change his vote, I move the committee to reconsider its action on LD 483.
Is there a second? Representative Sheehan, second.
I second the motion.
And so committee members, we need to vote on whether we are going to reconsider 486. And so Supi, let's do this as a roll call vote, please.
Thank you, Madam
Before
Chair.
we move on to that,
I'm
I
sorry.
apologize for not asking for discussion. Go ahead.
Well, you said 483 first, and then you said 486 second. So which bill are we reconsidering?
It's my mistake. I sometimes get numbers mixed up. It is 483. And that's the Civil Legal Services. Do I have that number right, everybody? Okay. Phew, thank you.
And the majority vote on that was an ought to pass as amended. The only amendment was striking out part of a cross-reference so the definition of debt collector included the debt buyers. And it was a majority ought to pass as amended with a minority ought not to pass.
Representative Hagan?
Thank you, Madam Chair. I can't remember this one, and it's not in front of me. I do have everything on my computer. Could we take a slight recess so that I could review the material before I vote?
Yes, that's fine.
What do you think, 5 or 10 minutes?
Yeah, should the first vote that we would do is a vote to reconsider, and then we would actually re-vote on the bill. Are you asking for a recess prior to the vote to reconsider?
No, not to reconsider. That's fine. No problem there. But I need just a minute to review my notes and remember this one, where I'm focused on quite a few bills in the last few days today.
Yeah, of course, and that's completely fine. So let's do the vote on the motion to reconsider, and then we'll take a 5-minute recess and then return. And does that meet your needs, Representative Hagan?
It does, and I appreciate it greatly. I have everything on the computer, but my desktop is full, a little busy lately, as you know.
Yeah, I know. I can appreciate that. Thank you. Okay, and so this is the motion to reconsider. And Supi, you can go ahead, please.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Babbage. Representative Babbage is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 are absent.
Thank you very much, Supi. So the motion to reconsider has passed. We'll take a 5-minute recess and return at 1:28 and move forward with the vote. Thank you, everyone, and thanks for the courtesy.
Thanks.
Thank you.
Looks like most of us are back. I just want to give, I know Representative Evangelos has joined us, but he had to step away for a minute, and I want to catch him up before we move forward, everyone. Representative Evangelos, I just want to catch you up on where we are. We have had a motion to reconsider LD 483. This is the Civil Legal Services Bill that we voted on last week. And the reason for the motion was as a courtesy to a member of the committee who wished to change his vote. And so we voted on the motion to reconsider. That passed, and then we were just taking a 5-minute recess prior to moving forward with the vote on the bill. And
Thank you.
yeah, do you have any questions?
No, thank you very much.
Okay. And I see that Representative Hagan has not rejoined us quite yet. Oh,
Sorry about that. I'm here.
okay,
Forgot
great.
to-
Are you able to move forward, Representative Hagan? We weren't able to hear you.
I finally found it and I'm ready to go.
Okay, great. All right, Representative Harnett, do you have a motion?
I do, Madam Chair. Thank you. I move ought to pass as amended on LD 483.
And do we have a second? Representative Sheehan seconds. And so just for the committees, to refresh the committee, this is an ought to pass on the legal services bill, and the amendment is just a technical amendment. There was a reference to subsection 6 that was inadvertently left in the bill that should have been stricken. And so the amendment is the original bill with those 2 words, subsection 6, also stricken. And with that, Supi, I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Babbage. Representative Babbage is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 6 members voting in the affirmative, 5 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much, Supi. And so the motion ought to pass as amended carries. And with that, and again, thanks to the committee members, we will close the work session, reopened work session on 483 and move on to the bills that are scheduled for a work session this afternoon.
And that one does not have a minority report attached with it.
I'm sorry. Thank you for reminding me very much, Representative Thorne. The previous minority report was a straight ought not to pass. Does that remain the minority report? Looks like it does. Thank you. And thanks for reminding me. All right, committee members. And with that, we'll turn to this afternoon's work. The first bill that we are going to take up for work session is LD 132, an act to implement the Attorney General's recommendations on data collection in order to eliminate profiling in Maine. And Peggy, if you could just do a very kind of top line summary of the analysis, and then we'll do a deeper dive. Thank you.
Great, thank you. So this bill was introduced in the second regular session last year, and it wasn't resolved finally before the legislature adjourned. It is actually a response to a bill that passed in the first regular session, which although the bill originally said do this data collection, the committee agreed that what really needed to happen was for some people to think about how that data collection should happen. And so they asked the Attorney General's office to review what other states are doing, work with stakeholders, and figure out what the options were. And the option, and Attorney General Fry reported his recommendations or his report in March of last year, and the committee decided to go forward with his option of kind of tracking what Connecticut and California do, which is collect information about stops that are made by their law enforcement officers. And the information that's collected is based on the perception of the law enforcement officers. So they're not looking at driver's licenses, and they're not asking the person whether they identify as a particular race or gender, but it's actually the perceptions, because the idea is to track if there's any kind of implicit bias, that the law enforcement officers don't even realize that they're stopping people based on their ethnicity or their race. So the idea is to have police officers collect that information from stops. Connecticut says it takes about 2 minutes to collect that information, and then report that information to the Attorney General's office. So that this creates a new chapter, sorry. And so the law enforcement officers collect the information, give it to the law enforcement agency without reporting the personally identifying information of the people who were stopped. The law enforcement agencies turn that information over to the Attorney General's office, and then the Attorney General's office looks at it and conducts analysis and consults with other interested parties, including public safety, as well as community, professional, civil liberties folks. They analyze that data and then provide a public report about what the trends are, and that gives the state an opportunity to figure out if there is profiling going on, and then to recommend some action. The sponsor presented an amendment to take out the provision that provided confidentiality for the law enforcement officers. The information about who has been profiled is already not collected, so that doesn't have to be made confidential. But that way the Attorney General could identify if the same thing is happening with the same people over and over. So it was a pretty long hearing, and you had lots of folks talking about whether this would be a difficult process and what the standards should be, because the Attorney General has to adopt rules to tell the law enforcement agencies how to collect the data. And there were just a lot of questions that neither the Attorney General nor the sponsor were able to answer. And the Attorney General was able to reach out to Professor McDevitt at Northeastern University, who has a lot of experience in working with different law enforcement agencies, I believe. And I'm hoping he is here. I see him in the attendee list. So I was hoping that you would be able to use him as a resource to kind of work through your questions. In the bill analysis, you do have the California law and the Connecticut law, and the committee last year used the Connecticut law to identify what they wanted collected. I hope that wasn't too detailed. Didn't take up too much of your time.
No, that was helpful, Peggy. And so yes, go ahead, Senator Kime.
Thank you. Peggy, was there any option, so obviously that this is to capture what is supposed to be officers making stops based on observations that they don't recognize they're making, right? So they're biased, but they don't know it. Was there any option there for no observation made? Because sometimes an officer is just pulling over a car and they probably don't see the occupant a great number of times.
Right. You know, that is a great question. And I'm hoping that Professor McDevitt, because he's worked with law enforcement agencies, he'll be able to explain what they do in those situations. I mean, it might be somebody who's driving really fast and you don't see who's driving the car until they've stopped. So I think that's a great question.
Thank you.
And so committee members, at this point, I'd like to bring Professor McDevitt into the panel so that we can hear from him a little bit about his experiences and ask him Senator Kime's questions and all of the other questions that we had. And I'm hoping that we'll also remember some of the questions that law enforcement officers who spoke at the public hearing had, so that we can ask those questions on their behalf as well. Professor McDevitt, thank you very much for joining the Judiciary Committee today. I don't know if you've ever spoken to this committee before. I'm actually kind of a newcomer to the committee, but we're very delighted that you're here today.
Thanks so much. Thanks for the invitation. I don't believe that I've spoken before this group before.
Okay. Could you begin, please, by just giving us a little bit of background information on kind of the scope of your work in this area?
Sure, I'd be happy to. Can you hear me okay?
Yes.
Great. Thank you. And I'll just be brief, and I really would like to spend the time answering your questions about how this is done nationally. But I'm a professor of the practice, and I'm director of the Institute for Race and Justice at Northeastern University. I've been there for a long time, doing research on police, hate crime, human trafficking, a variety of different topics. Specifically in the area of traffic stop by police departments, I've worked with hundreds of different agencies. We did Massachusetts, which is 350 agencies, and we did that twice. We did the analysis for Rhode Island, and that's 38 agencies, and we did that twice. I was part of the team that did the analysis for Missouri, which is 700 agencies. Done work in Seattle. Currently doing work in Douglas County, Kansas, which is Lawrence, Kansas, and the area, the community around there. And we've just started a project in Portland and South Portland, Maine, to take a look at disparities in treatment there. So I have a good deal of experience, and I'd love to share what other people have found to be helpful as we go through our conversation. To frame it just a little bit, I'd say that there's all across the country, as you know, after yesterday, we've just seen so much about it. People are talking about how and whether to reform the police and how different strategies might be helpful in making increasing trust between the police and various communities that we work with. And I would say that you can think of these strategies in two areas. There's sort of reactive strategies, which are going to improve the process once there's been an incident. And you see people like improved internal affairs units, professional standards units in police departments, civilian oversight boards that were put in place. And those are sort of to take care of misconduct when it happens. And then there's proactive, which are really looking at stopping it from happening. And those generally fall in the category of training. More and more, we're talking about body-worn cameras as a strategy that some departments are going to, and data collection. And what we're talking about today is data collection. I think that my experience has been that data is a useful tool for having community conversations. Probably all of you have been at one conversation or another with folks who are constituents. And, you know, what happens if we start to have a conversation with the police and people who are concerned about policing, you know, people will inevitably get up and say, you know, 6 months ago, this happened to me, or this happened to me when I was traveling to Massachusetts or whatever. And the police are like, well, we don't have enough detail, or that didn't happen in our agency. We can't help you. And there's frustration, and the word things don't go the way everyone wanted the meeting to go. Well, what we found is that if you're using data and you're showing people where the stops occurred, who gets stopped, who gets searched, who gets a citation, the anecdotes go away. And together, the community and the police can work to see if that's exactly the way they want the traffic enforced in their community. So I think that that's a benefit. The other thing is that the community sees police departments that will agree to collect this data as making a good faith effort to see if there are any problems. I've never found an agency where there was widespread bias out of all those hundreds of agencies I've worked with, where there's widespread bias among police officers. But I have found in many agencies, there's a small number of officers who, for a variety of reasons, and not necessarily bias, but it could be implicit bias, are making stops that don't look like other officers. So the last piece of background I'll share is that there are at least 4,000 police agencies. There's 18,000 police agencies in the United States. There are at least 4,000 police agencies that either have collected this data or are currently collecting this data. So there's a lot of agencies out there who are looking at it, who are collecting it, who are using it for management purposes, who are using it to identify if any kind of biases exist in their officers. And those agencies have made a bunch of decisions that Maine can learn from to not make mistakes that other agencies have made. And I'm happy to sort of show that, talk to you about that, and best practices that might be out there that people have tried and found a better way to do it. As I said, I go all around the country and talk about this. So pretty much as you started the meeting, and this is where I'll stop and leave you to answer any questions you have. You know, some of the main questions that police chiefs ask me, or the community asks me, is, should we have all stops? Or can you just do stops where there's a citation or a written warning? A second is, how do I record the race of the driver, much as you were just talking about? How do I know what a person is? And the third one is, police chiefs know that their officers don't want to collect more data. They don't want to fill out more forms. None of us do. And so how can I minimize the workload on my officers or deputies? At the same time, I'm getting sufficient information for an analysis that's worthwhile. And I can give you an example of how that's worked in a couple of places. And then we could get to the most complicated part of this, which is sort of, some of you will recognize it as the benchmarking question. But if I know I stopped 25% of the people in my community, in this community, who are African American, is that too few? Is that too many? How do I know? And so what do I compare that to? So those are the big questions I get when I go around, but I like to tailor my responses to whatever questions you all have. So I'll stop there and let you ask.
Thank you, Professor McDevitt. Committee members, would you like Professor McDevitt to kind of answer the 4 questions he raised since those were, I think, many of the questions that came up in the public hearing, or would you rather ask him specific questions? If you're okay with him, actually, I should ask you too, Professor McDevitt, are you okay taking us through answers to the 4 common questions you raised?
Sure, whichever works best for the committee.
Committee members, is that a good way to proceed?
All right.
Okay.
I'm seeing some nods. Okay, so go ahead, and then we'll open it up to specific questions.
So, one of the first question that I mentioned was, should we do all stops? And what I mean by that is you already have data on, although you probably don't have as much data as you need, but you have data on anyone who gave a citation to, and you have data on anyone who got a written warning. So agencies will say, can't we just use that? And the challenge there is, I mean, that's better than nothing. But what some people in the community will allege is that police officers will stop people of color and search them and then give them a verbal warning, and there'll be no record of it. And so when you go to do the analysis at the end of the year, they don't believe that all the stops have been recorded, and that they don't believe the analysis that you do. So most agencies around the country do all traffic stops. And we could talk about how to find that. I can get as granular as you like, but whether you use motorist assist as part of the thing, whether you use, there's a whole variety of different details. We don't have to get into that, but the basic one is all traffic stops. The second question that comes up is race, and you mentioned about that. And there's a couple different reasons. The majority of the thousands of agencies, the vast majority, as a matter of fact, I don't know any agency that doesn't use this, uses the perception of the officer to determine the race. And the reason for that is simple. Yes, absolutely. I'm going to make mistakes. Every police officer is going to make mistakes. They're not going to know exactly how people self-identify. But really the question is, did the police officer act in a way that was different because of her perception of an individual as being from a particular group? And it's not how that person self-identifies on the census. It's how that person is perceived by the officer making the decision. The same way, if you're walking through a shopping mall and somebody starts to follow you, it's not how you exactly identify yourself. It's how that security guard perceived you in order to see that you might have been a threat and they followed you. So perception of the officer is the way that the vast majority of agencies are currently collecting data. The other part of that is a practical question. So if you think about it, what some agencies tried to do in the beginning was to ask, could you tell me what you are? And that way the officer doesn't have to make a judgment. But then here's what happens. In the traffic stop, you end up with a situation like this. Excuse me, sir, I pulled you over because you're going 10 miles over the speed limit. Could you tell me what race you are? And at that point, the traffic stop goes sideways, right? Because all of us would say, what does that have to do with why you pulled me over? Why am you asking me this? And so police agencies have said that this is something that they don't want to have that kind of thing. Now, I know you folks have considered putting it on a driver's license, and a number of states have tried to do that. That offers some other problems on the other side. That means every time someone uses their license, their race is put out there for whoever's they're interacting with. But it could be something that you do, but it really, the decision maker there is the police officer. And if I'm doing an analysis, let's say we're comparing whether the police officer gives warnings in some cases and citations in other cases, you really want to know what that officer or that sheriff's deputy perceives that person to be that might be covering their behavior. The third question was about, and I'm more than happy to drill down in any of these and try to offer what insights I might have. The third question was on the balance of workload. Every police chief that I've ever worked with doesn't want to add more workload to their offices. Their offices are busy. They don't want to add more. So the question is this going to add a whole lot more workload to my offices? And can I minimize that? So first of all, as you heard in the opening remarks, it takes from 30 seconds to 2 minutes, depending on how much information a stop generates, like is there a search, things like that, to fill out the form. Generally speaking, it's very minimal. Very few agencies, after they've had the initial, nobody wants to fill these out. So after the officers have gone through the initial stage of it, they don't think of it as work at all. It's just something that I do. But I wanted to give you an example from Massachusetts. The police chiefs, when they did the first study, they wanted to minimize the workload for their officers. So they said, I want to just know if there was a search. That's all I need to know about, just a search. So the question was search, yes, no. And they just checked the box. Then when the analysis came by, it was the case that in Massachusetts at the time, they disproportionately searched people of color across almost every agency. As a matter of fact, in the literature, that's probably the biggest area of disparity across the country in searches. And then the police chiefs were thinking about it, and they go, wait a minute. There are some searches that are non-discretionary. So if I'm arresting someone, I have to search them to take them into custody. Or if I'm seizing their vehicle because they don't have a license or the registration has expired, I have to search the vehicle so I can assure that the person gets all their property back. So those are non-discretionary searches. So I want to take those out. Well, they couldn't, because all they knew was there was a search. They didn't know what was the type of search it was. So what they did was change the form and went back out in the field and added a form that said, what's the reason for the search? And so there's a bunch of places like that where we've learned over time what information you need to be able to have a fair assessment of whether or not there's any disparities. And the benchmarking or comparison one is, very complicated, and I'm happy to talk about it in detail. But basically, you can't use census data. You can't say who's in Portland, and here's the population of Portland, and here's who we pull over as the Portland Police Department, and they should be the same. They won't be, because lots of people who don't live in Portland drive through Portland. So it's got to be, so you have to change that number and adjust it. There's a variety of ways people have done it. But there's two other things that I think work much better than fighting about what's the best comparison, because there is no perfect comparison, is what they call post-stop activity and also internal benchmarking. And I think both of those are helpful and maybe the way you want to go. Post-stop activity is after the officer has stopped the car, gone up, had a brief interaction with the driver and gotten the driver's license and the registration. What decisions does that officer make at that point? So in other words, they're making a decision of, am I going to give this person a citation or am I going to give this person a warning? And there, you don't need to know what he's comparing them from. You're saying all the stops that particular officer made, do they give citations to African-American drivers who are speeding at more than 10 miles over the speed limit at the same rate they do that for white drivers? Sorry. So that's one thing. And then what I mean by internal benchmarking, and this is where I found most of the challenges when in statements in the agency I've worked with, is don't compare it to external, compare it to other officers. So if officers are compared to other people who work the same shift or work the same area of a community, then they should all be stopping pretty similarly the same amount of people. And you would hope that they would be giving similar kinds of citations or searching people at similar rates. And if somebody's a huge outlier, that they're searching all kinds of people, then you might want to, all that does, it's important to understand this, disparities don't equate to discrimination. There's lots of legitimate reasons for disparities, that you may have a racial disparity and it may be completely legitimate. I'll give you an example. I work in Boston all the time. If I'm thinking about Boston, and let's say that there's a particular spate of gun violence in a community, and it's caused by members of a particular gang, and they're fighting with other people from another gang. unfortunately, in Boston, most gangs are young men of color, and they generally are the same ethnicity. So what we'll see is that that group of people is going to get stopped more. And that's a disparity, but it's probably very good policing because people are dying with being gun shy. So all that this kind of analysis does is points us in a direction where more questions can be asked. And frequently the police department can go ahead and give a very good explanation as to why this group is being stopped more. And sometimes they can't, and they can't, then you want to think about, well, is there a problem here with bias? But so it's a multi-step process that empowers the police department to make these decisions on their own and how they would do it. What I started with is saying that when I go to community meetings with data and show them where the stops are being made, who's being stopped, as you all know, a lot of your communities are concerned with speeding. They're concerned with people going through their neighborhoods at a rate of speed is going to kill some young child that runs out in the street after a ball. And they want enforcement of traffic, but they want it to be fair. And so how is that done? And can the police show that they're going where the people are asking them to go? So those are some responses to the 4 questions that we get most often. And in the benchmarking question, what I would say to you is a couple of things interesting. Not one measure is perfect, but we look at multiple measures from every community. So if you see that Latinos are being stopped more in this community across the board, and they get more likely to get a citation, they're more likely to be searched, and they're more likely to be stopped, that would give you some confidence that we need to do some work with them. We maybe need to do some training. We need to do some, conversations with that agency, because you have multiple indicators. One indicator is never going to be enough to sort of start that conversation. So I'm happy to stop there and respond to any questions or thoughts or comments.
Thank you very much, Professor McDevitt. You've given us a lot to think about, and I want to open it up now to questions from committee members. Representative Moriarty, I think your hand was up first. Go ahead.
Okay, thank you, Madam Chair. Professor, I have a question for you regarding a possible tendency on the part of an officer to sanitize the report. For example, if original perceptions were not valid, and yet the officer is completing the form following the full completion of the stop, have you noted, or is there found to be a tendency on the part of some officers to correct their original perceptions, or to make sure that the data recorded is in fact true as opposed to merely perceived?
We've seen a lot of initial reactions from officers that are similar to that. Not as subtle as you're suggesting. One of the things that happens when you first start to collect the data is some officers said, I'm not going to collect data that you're going to use to call me racist. So they don't stop anybody. They just stop making traffic stops. And, cops can do that for a week, maybe a month, but then they go, hey, wait a minute. This person's going to kill somebody. I'm just going to be a good cop and stop him. So we see a little dip, but it comes back up. We also see officers who leave the race section blank. I'm not going to get them mixed up in this. I'm just not going to fill it out. And in electronic ones, you can make them fill it out. But the more real reason is that supervisors in police departments, as you all know, already do quality control on things like arrest reports and incident reports and all of those. And they would just do quality control here. Now, you can do spot checks on person's race to make sure that it's done accurately, because you will have a race on arrest reports in that agency. So if the person's ever been arrested before, you could just run a quick check to see if the race that they were reported when they were arrested was the same race that's here. It's interesting to note that in most police departments across the country, no one asks your race when they're filling an arrest report either. They just fill it out at the way you appear in the police station. But you know, there are ways to check. And I would say that whenever you start an effort like this, the first couple months are just a shakedown cruise. You're not going to use that data. We always don't use it not because it's malicious, but people get confused. Do I put it in this box or this box? How do I fill this one out? What if I skip this? You know, and and you know, it's just a training issue for that. But I have seen what you said, but more often I see more of the sort of, I'm just not going to fill these out, or I'm not going to do any traffic stops.
Mhm. Thank you.
Senator Keim, you were next.
Thank you, Madam Chair. And I have just a few questions. Is it all right if I just go through them rather than go on and off and on? Okay, thank you. Thank you, is it Professor McDevitt?
Yeah, it's Jack. How's that?
Okay. Thank you, Jack, for being here. I appreciate it. So I had a few questions. They're really kind of almost short yes or no things. So electronic form or paper form is how these are being filled out?
Yeah, almost everywhere now is doing electronic, but there still are some small agencies that use paper for other forms, and they do paper. Usually it's made out to look just exactly like a citation. But so we've done it both ways, but more and more we're moving towards electronic forms. And just to give you almost every major records management system in the United States, PAMIT, Motorola, all the ones that most agencies have, there's a sheet that they probably don't even know they have it, but there is a data collection screen for traffic stop data collection. And they could just ask about that and it can be made viable for them. So, but I don't know all the agencies in Maine and you know what their current practices are.
Right. And is there on the forms you've seen an option for no observation made?
Well, I heard your question about that before. A number of places have tried this idea that when I pulled them over, I pulled this person over by radar. I had no idea who there's many times the police officer doesn't know who they're driving the car at night, in the rain, in the snow. You know, you just don't know who you're pulling over. The challenge is, so they had a field that said, I didn't know the race when I pulled the person over, but once I've had the interaction at the car and I have the person's driver's license, then all those agencies have the officer record their perceived race at that point in time.
Okay, so after their interaction, they're then asked to do a perceived.
Yep.
Okay, what their perception is. But in the form is noted that they're making that observation after the stop as opposed to prior.
Some places do that.
Okay. Is religion one of the biases that's asked to be on the form?
Not generally, not most of the places.
Okay.
They do have things that be correlated with religion, Middle East status, you know, but not religion.
And then what about when there's like a roadblock up where just every car is pulled over? Are they requiring them to fill out forms on all of those as well?
Usually they are, but they also fill them out as a part of a special detail, because they, you know, like a click it or ticket kind of program where they'll be stopping people in a first section of the city. And so what would happen is the reason for the stop would be a special detail and then those can be removed from the analysis if they're, you know, if they're not something that's subject to discretion.
Okay. And then, so the premise of this bill is that officers are biased. And I'm wondering how practical it is if we consider that if we're trying to capture who is biased, then why would they be truthful on this?
Right.
So if I was an officer that made biased stops and I recognize, you know, that's who I am and that's what I think, then why would I answer honestly?
Well,
so then how valid is the information, I guess, is where I'm getting that.
Sure. No, I think that it's a great question. I mean, I guess I take a step back. I think we all have our biases. And so not just police officers, certainly all of us do. And many of them are implicit, as we all know. And police officers do things that they don't even think of as being biased. But if you were a racist cop and you know you want to pull over people of color and you want to, that's who you want to pull over, you could mark them all as white. But as I said, what we suggest in all agencies is to correlate just a sample of cases, with other indicators of race that you might have, like arrest reports. And that way you'll start to see, well, wait a minute, this person's on the arrest report, they say they're black, and on this traffic stop, they say they're white. And if that happens in a consistent pattern, you'd say, maybe the officer is not recording this accurately. So you can audit the data.
Understood. Thank you.
Did you have other questions, Senator Khan?
I don't. I'm all set.
All right, thank you. And I'm keeping a list here. Representative Hagan, you're next.
Okay, thank you very much, Madam Chair. Thank you for being here, Mr. McDevitt. I'll go back to, you had started with 3 questions, so I typed as quick as I could. I may not have gotten them right. Question 3, basically my interpretation of what you said, if the cop asks what race a person is, then that causes trouble, and law enforcement may not like that. And then you talked about some people might have issue with putting, they may find it problematic to put race on a driver's license because that exposes them. So if those 2 things, let's say, were, say, in this work session, taken away from an option here, what would be a more productive fix?
I'm sorry, I didn't understand that. If we weren't going to put it on the driver's license and we weren't going to use the perception of the officer?
Correct. And then would there be a third alternative that I'm not thinking of?
Well, nobody else in the other 4,000 agencies are either. No, I think you've got the option. I mean, I think that self-identification or the perception of the officer are the 2 places, and they, like I said, 99% of the agencies that I'm aware of are using perception of the officer.
Okay, thank you.
Sure.
So, you all set, Representative Hagan?
Yeah, I was just, the thought had crossed my head as he was talking. I thought, well, I'll just type every thought I have, and then I got to thinking about it. Well, maybe there is an answer, so that's where that came from. Thank you.
Yeah, thank you. I think next was Representative Harnett.
Thank you, Professor McDevitt. We appreciate you being here in front of the committee today. One of the things we sometimes hear when we talk about these issues in Maine is Maine's a predominantly white state, that we don't have a lot of people of color. And one can agree with that or not, but those will say that, will say, well, we can't get any data. We really can't get data that demonstrates if there is implicit bias amongst departments or individuals within departments. Have you done work with police departments in states with population demographics similar to Maine?
Absolutely. We did not statewide, but the Vermont State Police as one example. And in Vermont, we did the whole state with the state police. And they found that there was disparities that they felt troubling that was in the north part of Vermont up by the Canadian border. And so they did some training around that. I believe, and also, in Kansas where I am, it's 80 to 90% white area of Kansas with the exception of the university. And so that they also have very small numbers, but we do see pockets of places where people, there are disparities. And let me give you an example. This was a good officer who was doing a good thing, trying to do the right thing. So there was an officer in one community that we worked with in Rhode Island who every morning at the start of his shift, he drove to housing projects in the town. And he ran the license plates of all the cars in the parking lot in the housing project. And if he got a hit for a warrant, he either hung around or kept coming back till that car left and he pulled it over. And he was trying to do the right thing. The challenge was that he only did that, and this was the implicit bias part, in the African-American housing development. He didn't do it in the white housing development in the same community. Because his perception was, this is where the criminals are, and so I'll do that. So he was pulling over and arresting lots of African Americans. And, it might be a good strategy for all law enforcement, but everyone would want to have it equal-handedly across race in their community. So that's one of the things that's happened. I will also tell you that I've never come to a police chief and said, hey, there's a disparity here, when the chief said, I don't care, or that's okay. The first thing they say is, who's doing that? Let's fix it. I've never run into a police chief that thinks disparate treatment by their officers is okay. They want to fix that. They just don't know right now. They don't have the data on. As I say all the time, if you go to any police department in Maine, they can tell you everyone they arrested. They can tell you when they arrested them. They can draw a map of where they were arrested. They can tell you what they were arrested for. They can't tell you where they did their traffic stops. They can't tell you what they did the traffic stops for. They can't tell you which are the most effective traffic stops. And it's interesting, the Department of Justice does a study every year called the Police Contact Survey. And it finds that the number one place of contact between the community members and the police are traffic stops. It's the most frequent place we run into each other, the police and the public. Now, that's in professional capacity. I will tell you that the number one place where people and the police come together is for directions. We all go to the police if we see them. We don't know where we're supposed to go next. So the directions is number one. But in a professional capacity, traffic stops are number one. So it's something that has an opportunity to really increase trust in the community. And there's ways to do this in a fair and equitable way. And I think just collecting the data goes a long way to the community believing that this is something that's possible as a possible positive thing in the community. I'm sorry for going on.
No,
thank
you very much. May I ask one follow-up,
Yep.
Senator Carney? Earlier when you were speaking, you were talking about benchmarks and not just using one benchmark, and you talked about why relying on the census is not the most appropriate way to do this work. Could you explain that a little more?
Sure. If I take the census population of Lewiston, and I say, okay, well, this is the population of Lewiston, and then I take who the police pulled over in Lewiston, then they're not going to match, because people come to Lewiston to work, they come to shop, and they don't live in Lewiston. So one thing you can do is just take the stops of residents of Lewiston and compare that to the population of Lewiston. But you can't just compare it for all their stops. And then the one thing that's really interesting, and some states are doing this, I don't know whether it's not in your statute, and I don't know whether you'd want to do it, but what they found in analyses is the best way to compare who's driving on our roads is who's having traffic accidents on our roads. And so a number of places in Florida, in North Carolina, Massachusetts are collecting this kind of data on their traffic accidents so they can use that to compare. Because the people who are getting into particularly two-car not at fault accidents are very much looking like the drivers that are on the roads. The way we know that is we do studies, and a lot of people do studies where we put people out on the road to observe. And you do that during the day, and you do that on street corners, and you do that on highways, and you do it in a variety of different places. And over a long period of time, you get a pretty good accurate picture of who's driving on the roads. And so you take that and you compare it to the accident data, it looks good. If you compare it to the census data, it looks terrible. So that's.
Thank you very much.
Sure.
And Representative Thorne, you're next.
Thank you, Madam Chair. Thank you, Professor McDivitt, for showing up today and testifying on behalf of this bill. And I just, as a comparison, I want you to know that I'm a Republican and I get discriminated against on nearly a daily basis, but we all have our struggles and they're real. Glad somebody laughed. I can't help but think about unintended consequences. In other words, you get a police chief that briefs his force that, okay, this bill has been passed, and now we have to collect data on all the people that we stop. And the purpose of it, there's a kind of couple questions in here. This is to eliminate profiling in Maine. And I'm wondering how collecting data is going to eliminate profiling in Maine. Does that mean we're disproportionately pulling over people of color versus white, Caucasian people, and that this has identified it? So in order to eliminate profiling, don't pull over people of color as much. Is that or somebody's worried that, you know, I, as a police officer, I don't want to get, I don't want to get labeled with profiler, pulling over a disproportionate number of people of color than Caucasian folks. So if I see somebody speeding or possible violation, I'm going to let them go, because I don't want to have to fill out another. I'm at my quota for pulling over people of color.
It's a good question. And most police officers I know aren't biased, and they don't worry about it. And they're not going to adjust their behavior for something they don't believe is happening to them. And so they're not going to say, oh, I'm not going to pull over somebody who could get in a wreck and kill someone because I'm going to be on a form. The other thing is that in those 4,000 police agencies, I don't think we're dealing with more than a dozen officers who've ever been terminated for the data that they produce. I mean, it's not a common thing. I can tell you in Massachusetts, there was a state trooper who had a disparity. They brought it to his attention. Most of the time, that's all it takes. Bring it to the person's attention, unconscious bias, it goes away. The guy who was doing that at the going through the housing projects, he just stopped doing that and it went away. So in Massachusetts, they had a trooper. They talked to him. They went back 6 months later. His biases were just the same. They compared him to other people working the same stretch of road. It was very different. They threatened him with discipline. They disciplined him. He still didn't change. And then they terminated him. But it was 2 years of them progressive discipline before they ended up terminating. And it wasn't, they never went public. This was something you'll never read in the press. It was terminated, you know, within the agency. So I do think that the provision of trying to keep the officer's name out of the public is a really good one. But you have to be able to identify them for the chief so that the chief can deal with it. But I don't see people changing their behavior just to avoid profiling, because there aren't very many police officers that think they're doing it.
Mm.
And again, if we're auditing it, then they're going to get caught, and they're going to probably have more difficulty explaining why they're filling out a legal form inaccurately than they are some crazy analysis done 2 years later about how many stops they made.
And a second part to that, if I may, Madam Chair, is
Yes, go ahead.
I guess, Professor, what I think about is small rural towns that there is no issue. Or I just worry that we're making an issue out of something that may not be an issue in 98 out of 100 communities with the police department. I mean, I don't know that, you know, Fort Kent, Maine experiences police racial profiling, but yet they're going to have to adhere to the same new guidelines as a town that like Portland that is going to be right on top of it because they have a more diverse population. And I just don't know, you know, one size fits all seems to be the approach.
Sure. Let me just, in Massachusetts experience, you know, there's obviously some very white, very rural communities in Western Mass, and they, you know, have had the same concerns. But one of the things that does happen that the police chiefs in Massachusetts like was they have this data for management purposes in addition to determining racial profiling. So they can say like, hey, Jim hasn't made a stop in 2 months. What's he doing? I didn't know that from before. I didn't pay attention to it. Now I know it and I can look at it. Or, you know, Sue is doing stops way over on this side of town, but this is her beat. Why is she over here? And then they can also start to say, well, look, we put the blinking light that says you're speeding in this place where we wanted to stop accidents, and we put a police officer in this place. Was there any difference? Is there a better way to deter, you know, reckless driving? And they can ask that question. So police chiefs can use this to manage their officers as well as determine, and police do, as well as determine whether or not there's any bias policing.
Thank you.
Thank you.
Representative Evangelos?
Thank you, Madam Chair. I'm Professor McDevitt. I used to spend some time on your campus when I was a little kid.
I may have been there then.
It was in the 1960s. My dad was chief of police and director of security at Northeastern after he got done being a Mass State cop. So if you were there in the late 60s,
I got there in 77, so a little after that.
I was mostly going to the football and basketball game. But anyways, this is a very concerning topic to me. You're probably not aware, but we have had some video footage leaked to the press. Must have come from the attorney side through disclosures. Nobody took credit for the leaks, but this is quite recent, of racial profiling incidents on the main turnpike. And the officer who is perpetrating this, it turns out, has between 40 and 50 outstanding complaints about racial profiling. But on this film, he's using racial epithets towards African-American people. And he's pulling people over because they're driving in the middle lane of a 3-lane highway. You know, he's making up excuses as he goes along. But how important is the prompt release of cruiser and body cam footage in these sort of incidences?
Well, two different things, right? But I'm happy to answer your question. I did do a study. I did the study of body cam, was in Boston. But one incident of a stop is never gonna, and having a form that comes out is never gonna cause any controversy, or no one's gonna want to look at it because they need to look at the pattern. And so you have to have all of the stops of a given officer to see if that officer is engaging in a pattern of practice that's illegal. In terms of the body cameras, though, any interaction like you're suggesting, where an officer misbehaves or engages in misconduct, then the police practices right now is to try to get that video out as soon as possible to try to inform the situation. I think that the young woman that was killed yesterday, and during the stabbing, they put that video camera footage out very, very quickly. I do think that the one place where we're missing on body cameras is that it's one of the best training tools we have available. But the problem is the volume of the camera footage is such that very few people look at these. The supervisors don't look at them. Some agencies, what they've done is said to the supervisors, you have to look at the body cam footage of your officers, the 3 or 4 officers you supervise in that shift. And that then you have to pick one thing that an officer did really well, and one thing that an officer could do better, and do that in every shift. But that's very rare. Most of the time, this stuff is never reviewed unless there's an incident and they pull the camera footage for that incident. So I think from your point of view, training practices would be really enhanced if people were looking at this and the idea about how can we help officers do a better job, stay safe, and be fair and equitable to the community.
So you think the release of this footage enhances transparency in the public's faith then in law enforcement?
Yeah. I mean, as long as it's some of these body cam things are difficult to watch and difficult to understand what's going on. But if it's clear, yeah, it's helpful. The community likes it. Yep. The other thing that we found in Boston is it also is very important to jurors when they're trying to make their determination if a case is going to court. Sure. So this stuff is becoming, it's complicated though. It really is.
Sure.
Because if you think about it, the people in the body cameras are often people who are at the lowest point in their life. I mean, they're being arrested. They're, just been a victim of crime. They may have been drinking or, something like that. And they, I always, when I'm reviewing the video camera footage, I'm like, God, I hope my kids never see anything like that with me in it. So I think the privacy issues are real too when we think about that.
The problem in our state, just so you know, is it's the policy of the state police and the Maine Attorney General's office never to release the footage unless the investigation is closed and complete. So we never get any transparency here. They fight us every time, even though they have the discretionary authority to release it, they won't. I myself filed a request with the state police's attorney to release data on all 45 racial profiling stops of this state police officer, and they're stonewalling me. The only one they've admitted that the complaints are real, but they won't release any of the evidence, even though they have them in their possession. And that leads me to Senator Kimes' concern. How confident are you that the police who do routinely engage in this activity will tell the truth? I can assure you in my state, they won't.
Oh, where we've done the checking, we find that most police do, but I haven't done an analysis in Maine, so I can't speak to the case in your state.
You're not familiar then with the plethora of news media and newspaper articles that have come out in Maine in the last 3 months. A day doesn't go by that we don't have reports of serious police misconduct. Are you aware that that's going on up here?
Vaguely. I mean, I've seen some of them. I'm sure I haven't seen all of them.
Thank you.
Sure.
Committee members, that takes us down the list of folks who raised their hands. Are there additional questions for Professor McDevitt? Can I ask you some really practical questions, Professor McDevitt?
Of course.
So how, if this bill were implemented, how much time would it add to each traffic stop for the officer to fill out the form?
Yeah, either in paper or electronically. And obviously, if you could do it electronically, that's better because there's a step that gets dropped out by having somebody have to take the paper form and type it into a computer. But either is between 30 seconds and 2 minutes. That's it. It's very, very quick. They just go through and click it. Most of them are going to be, I stopped the person, I gave them this ticket, this is the reason I stopped them, and 6 or 8 items of information. But then if there's a search or if they seize the vehicle, that may take a little bit longer. But it's very quick.
And then as far as you were referring to, there's an electronic form. Can you talk to us a little bit about the technology needs and the expense of using an electronic system?
Well, it's a better system, but it depends on what the agency has. If they're already using a system where the officer keys in, a report for a incident that they're going to report on. So, they get called to a loud party and they key in, this is a services rendered, this is what I did, here's where I was. Then this is something that's pretty nominally for them to just have another screen that they could pull in for a traffic stop. And like I said, all of the big companies have this and have had it for a number of years, all your big providers. And I don't know about Maine. I know in Massachusetts, 90% of the police departments are using 3 providers for their records management system. And they're all, all of them have these screens. So the cost involved is if you want to update the screen for some particular interest of your community, then there's a cost in programming that. Not terrible, but there is a cost in that.
Thank you. And and then as far as recording data, in addition to the officer's perception of race, are there other data points like gender or age that are recorded as well?
Yep, almost all of them will record the person's age and gender, not religion, as something I think Kynes was asking before, not religion, but something about ethnicity. It depends on where you are. In San Diego, they record 17 different ethnicities. So they ask their officers to differentiate whether you're Vietnamese or Cambodian or from Mexico or El Salvador. I don't know how they expect their officers to do that, but that's something that's important to them and their community. So they break it down much finer than any place else in the country does.
And then my last practical, well, it's not actually a practical question. I'm just curious. So you said that there are 4,000 different law enforcement agencies that are using this type of technology and capturing this information. Where are those located? Are they predominantly in one part of the country or another? Are they predominantly rural or urban? Can you just give us a little bit
It's
more
a pretty
information about that?
broad, yeah, pretty broad cross section. So Connecticut has a statewide mandate, but as does Missouri. And Missouri has, just like as you're considering, has it's recorded and sent to the Attorney General's office, who posts it every year. Texas has a mandate. California has a mandate. Washington State has a mandate. So they're all different kinds of states, conservative, liberal, they all different places where they found that this data is helpful, and the community thinks that it's moving the police department in a correct direction.
Thank you. And committee members, I just want to make sure that nobody else has questions for Professor McDevitt before we extend our thanks to him and move him back to the attendee place. I'm not seeing any. Thank you very much for spending so much time with us this afternoon.
Thanks so much. I hope it was helpful.
Thank you. Committee members, we have spent a lot of time on our work session, and I hope that you found the information provided by Professor McDevitt to be helpful. At this point, I would like to, I think if we can return to Peggy's analysis, and committee members, if there are any additional questions you wanted to ask Peggy before we start our committee discussion of the bill. And I'll also, I think the bill sponsor is in the attendee space, and I want to, she wasn't there earlier, but she is now. And so I'm going to bring her onto the panel as a courtesy to her as well. But first, let's additional questions for Peggy about the bill analysis. Welcome, Representative Talbot Ross. I'm not seeing any questions for Peggy. Are there questions for the bill sponsor? Go ahead, Representative Harnett.
Thank you very much, Madam Chair, and welcome, Representative Talbot Ross. Just a clarifying question for me. This bill, and correct me if I'm wrong, LD 132 is about the collection of data. It is not about racial profiling. Is that correct in your mind? Getting the data to see how law enforcement agencies are acting.
Well, good afternoon, distinguished members of the judiciary, and thank you for the question, Representative Harnett. Before I answer that, I just want to add my gratitude and appreciation to Professor McDevitt for being with us here in Maine and providing such expertise in this area. His work is brilliant all over the state, all over the country, and he's been doing it for well over a decade. So just wanted to give my respects to Professor McDevitt. You are correct, Representative. Racial profiling is already against the law in the state of Maine. So this is not a debate about whether it exists in one county or one town or one municipality in the state of Maine. That debate has already happened. And whether or not there are incidents of racial profiling in any area of the state, or whether or not there is the presence of Black or Indigenous or people of color in this state in any given area, it is against the law to racially profile. That's a full stop. It's against the law to racially profile in the state of Maine. What this bill does specifically is to try to capture information that may help all Mainers in every area of this state remain safe and free from discrimination and profiling. This is simply a data collection bill. It is a tool for us to get accurate information so we then can take all the steps that we need to ensure that every single Mainer enjoys equal protection under the law. Thank you.
Thank you, Representative.
Representative Hagan?
Thank you very much, Madam Chair. It's nice to see you again, Representative Talbot Ross. I had a question that I thought you had went over the testimonies and whatnot. And it talks about law enforcement officers providing their name also in the report that is sent. And I was curious as to if this bill is to keep, people free and safe, and this bill is only a data collection bill. I fail to understand why the name of the officer would be, would be used. So my question is, can you explain how, how this would be productive or problematic in your eyes down the road if this bill passes?
Well, thank you, Representative. It's wonderful to see you as well. I do miss hanging out with you folks in Judiciary Committee, and particularly Soupy and Peggy, who are just absolutely brilliant public servants that we cherish. I would answer it this way. First of all, that information on the individual officer goes only to the Attorney General, which, as you know, is the top law enforcement enforcer in the state, top law enforcement officer in the state. So that information is not going to the public. It's going to the Attorney General. So for all intents and purposes, it's being kept internal. The reason for that name to go forward is, I'm sure you would agree, that what we want to ultimately uncover is if we have a pattern in practice of biased law enforcement behavior. The only way to do that is to, for the Attorney General, as the depository of that information, is to be able to know specifically which officers we are dealing with. Again, that's not information that goes to the public. It is information that the Attorney General uses in order to determine, Representative, if we have a rogue law enforcement officer, or if we have a department in the state that has shown pattern in practice. So it's information that informs us. It's not information used to penalize or demonize any particular officer.
May I ask a follow-up?
Yes.
So in lawsuits happen, and people break laws, whether it's law enforcement or not. Down the road, lawsuits happen. Would there be the ability of defense attorneys or prosecutors getting the names of those officers that were privately placed with the Attorney General? Would there be an avenue where they can use these things in the course of a civil or criminal suit?
So thank you for the question, Representative. I will respectfully say that that is not what we're debating in this bill. That is a projection that I am not going to, give my personal opinion about that. I would say to you that under the Freedom of Information laws here in the state of Maine, that this bill will not, expand or decrease that ability of the public under current state and federal law to know actions by any public servant or public employee in the state of Maine. But I do think that that is a projection that is outside what you're being asked to consider in this bill today, respectfully.
Thank you very much. Appreciate it.
Committee members, are there additional questions for the bill sponsor? Representative Harnett?
Thank you, Madam Chair. I just want to follow up on Representative Hagan's question, Representative Talbot Ross. and again, correct me if I'm wrong, but one of the things Professor McDevitt mentioned, and I've heard you mentioned during testimony, is one of the goals of this bill is if we identify a problem, it's not simply to discipline, it is also to conduct training for departments or individual officers whose behavior might demonstrate an implicit bias, not necessarily an explicit bias, an implicit bias that influences their behavior on the job. Is training part of one of the outcomes that can flow from this data collection?
Thank you, Representative. Absolutely. I mean, absolutely. You know, one of the things that I love about Professor McDevitt, what he said, and he's been, you know, clear on this since I've known him over a decade in all of his work. And I think his response to Senator Keim really highlighted it, that this is you know, the biases that we hold, no one is exempt from them. This is part of who we are. And our duty, though, is to make sure that those biases aren't used to disproportionately or, you know, impact folks who are supposed to be equal under the law. And so this is really about learning about our biases. It's about public safety. It really is about public safety. And we all of us, every single one of us needs to continually learn and grow in this area of work. So it is definitely about education, definitely about training. And I would think that for our law enforcement personnel, they would see this as an additional tool and a benefit to their work. So thank you.
Thank you, Representative.
Representative Evangelos?
Thank you, Madam Chair. I'd like to make a motion.
Go ahead.
I'll make a motion to pass as amended.
Thank you, Representative Evangelos. Is there a second? A seconded by Representative Sheehan. And before we move on to discussing the motion, I just want to check in. Representative Evangelos, is the amendment that the bill sponsor submitted with the at the public hearing?
That was my intention.
Thank you. So if, with the committee's permission, I would just like to ask Peggy to review that with us, because it has been a while since the public hearing, and I think it would be helpful for all of us to have a little bit of a refresher on exactly what the amendment is.
Yep, it's really simple. I can share my screen for just a couple seconds, if that's okay.
Great, thank you.
So the amendment was attached to Representative Talbot Ross's testimony, and all it does is it amends the last section of the bill, and it gets rid of subsection 2, which talks about confidentiality, and so you don't need to call that first part subsection 1 anymore. So all of this replaces section 4754 lines 13 through 27 on the bill with just that very first paragraph. So it still requires the Attorney General to report to Judiciary and Public and Criminal Justice. The report includes an analysis of all the information that's collected, make recommendations or changes. It could be changes in practices, not just laws. And the information reported may not include personally identifiable information. So the report is not supposed to target people who were stopped or law enforcement officers either.
Committee members, any questions for Peggy? Peggy, could you please end the screen sharing? So the pending motion is ought to pass as amended by Representative Evangelos, seconded by Representative Sheehan. And so now we turn to committee discussion on the motion. Would any committee member like to be heard on the motion? Go ahead, Representative Evangelos.
Thank you, Madam Chair. Very briefly, Representative Talbot Ross, thank you for bringing this forward. You know how I feel about these issues, but you know we have a lot more work to do. This is a small step, and we have a major systemic problem in this state, and we're just beginning to address it. We see it all over the country, and it's going to take the commitment of all of us, including the Attorney General and the police, to get on board with reform. So I'm supporting this because this is a first important step, but this is just a beginning. Thank you.
Committee members, other discussion of the bill? Go ahead, Representative Hagan.
Hi, I had a few questions from earlier testimonies at the hearing from Major Scott of the State Police, wondering if we could bring him up and ask a few questions at some point, whenever it's appropriate.
I had that same question, Representative Hagan. I'm really glad you raised it. Representative Harnett, I am inclined to bring Major Scott onto the panel, but did you wish to speak first?
I can wait until you've done that.
All righty, thank you. We are going to bring Major Scott onto the panel. Thank you for joining us, Major Scott. I'm sorry I so unceremoniously and quickly brought you through cyberspace without giving you even a chance to catch your breath, but we're happy to have you join us today. And Representative Hagan, did you have specific questions for Major Scott?
Yeah, I had several, but I thought it would be more appropriate if I asked one and then let other people do their thing and then just put my hand up and came back. Would that be?
That's fine.
Okay. So my first question, nice to see you, Major Scott, again. My first question was the same one that I had with Representative Talbot Ross. When sending the name of the law enforcement officer with the report, do you see problems down the road if this bill passes and that happens?
Thank you. Can everyone hear me all right? Great, thank you. Well, good afternoon, Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Major Brian Scott with the State Police. Happy to answer that question for you, sir. So in particular, as far as having personal identifying information that's forwarded to the Attorney General's office for law enforcement officers and for members of the public that are stopped, I don't see that being an issue on the surface being shared with the Attorney General's office, as long as that data is later refined and PII is stripped before any annual reports are submitted to either the Judiciary, Criminal Justice and Public Safety Committee, or it just becomes a public document at that point. But the Attorney General's office having that information, I don't see a concern with. Thank you.
Senator Keim?
Thank you. Thank you for being here, Major Scott. I just had a follow-up on that because I'm wondering, so wouldn't prosecutors be looking for that information and defense attorneys entitled to provide that? I mean, looking for that if there wasn't concern about bias of the police. And so wouldn't this information then be able to be made public?
So, Senator, I think that is a great question that you ask. And I think that would probably be important for this committee to make that distinction and to make that determination now as to whether or not that document would be subject to FOA under Maine Public Records. I would like to think that maybe the protections would be, when that's sent to the Attorney General's office, that information in and of itself is not a public report for the purposes of the Freedom of Access Act, that only the final report from the Attorney General's office that strips the PII is a public document. So I would like to think, unless we had a court order, that something like that wouldn't be released for the reasons that you just stated.
So would a court order be something that would happen though if there was an issue questioning some allegation based on an officer misconduct? Would a court order then be able to get that information? I mean, or would it be requested, I guess?
It's Senator Keim. I think the answer is yes. There is a possibility that would occur. There's a possibility that a request could be made, and there is a possibility that a judge could order that particular information to be turned over. So I guess the safest answer, if the committee shares that concern with the information, is that it's not sent with the PII anywhere. I'm just not sure how we document that otherwise, unless the initial portion of this, there's going to have to be a technology solution. I'm happy to talk about that a little bit as well. In order to collect, this is going to be huge amounts of data. I mean, just for the state police alone in the last 5 years, we conducted over 350,000 traffic stops and another 500,000 commercial vehicle stops. So it's going to be huge amounts of data with a ton of information. So I think it probably at some point get documented with certain pieces of information. The safest answer is, if you're truthfully looking for information in aggregate, that PII is never included. But if and I heard from Representative Talbot Ross that part of the reason for her bill is also so that we can identify if there are areas of concerns or trends in a particular, I guess, area of the state, particular agency, particular officer. And I don't know how you have that data if you don't include it. So I do share some concerns with that information potentially, being used outside of its intended purpose that we're discussing here today for the Attorney General's office to be able to sanitize it and produce aggregate data. So I think it's a tough decision that the committee will have to make if they want to prevent that data from being shared. I think the only way to ensure is to not include it to begin with.
Right. So then just to clarify, so if it's considered exculpatory and it's Brady material, then that would be released.
Yes, that would be my understanding, that it would be released.
Thank you.
You're welcome.
Excuse me, Representative Thorne.
Thank you, Madam Chair. Welcome, Major Scott. I just wanted to thank you for the job that you do with Maine State Police, a branch and division that we can all be proud of. And I guess my question for you is from as a major in the Maine State Police, you pretty much have a handle on it, and you've probably been in the law enforcement arena for a few years, I would estimate. Do you see this as an issue that's worth this activity that this bill would generate? Do you see is racial profiling, or I guess racial is not even in here, profiling? Is profiling that rampant of a problem in law enforcement that you feel that we need the need for this bill?
Representative Thorne, thank you for the question and for your comments. I appreciate that very much. It's my honor to serve. And yes, I've been doing this for the state police a little over 23 years, about 27 years in total. I am not personally aware of significant problems surrounding profiling in the state of Maine. But having said that, I do recognize that this bill is not about that conversation's been had, and it's about whether or not we should collect the data to I guess, better aid all of you, along with ourselves as law enforcement administrators. If there is a problem, we would certainly like to know about it. My belief is it's not significant if it is. I personally have not heard of very many complaints in my entire career. Certainly very few with the state police and very few with other law enforcement agencies. However, data collection, if it's good data, and my concern is about this data, whether or not it's good data. If it's good data, I think we can all learn. If there are areas for improvement, we should strive for that, and we would be, happy to work on any deficiencies that we identify as a result of having good data. It does sound like a pretty important topic for several folks. So we would leave that to the committee to make that determination. If you think it's important that we collect the data, we want to do it in a responsible way. We do have some concerns about collecting the data, how it would be done, what the data means, what that technology solution would be, the cost associated with it, the time associated with it. It's work, but if this committee determines that it is a priority to have the data, then we can certainly comply with any statutes that come out of it. So sorry for what might be a long way to answer your question. I'm not personally aware of significant profiling concerns in the state. However, I believe there is always room for improvement in everything that we do as a public profession, as a law enforcement profession, and we could potentially glean some information from this data that could be beneficial to Maine citizens and to law enforcement as a whole.
Thank you. May I ask a follow-up question, Madam Chair?
Yes, go ahead.
Thank you. And Major Scott, I'm hoping that you can answer this to help me put this bill into perspective. When was the last time that there was a major implementation of a program that maybe paralleled this, that allowed to gather information and study, and what came of that, if you may be able to recall?
So Representative Thorne, nothing this sweeping or significant by way of data collection. I guess the one area that I could think of that we did go through would have been, and this was mentioned earlier by Professor McDevitt, regarding crash reports and crash analysis. We did have several questions that came up from the Transportation Committee several years back, wanting certain pieces of information regarding crashes, and we simply didn't collect the data at the time, so we weren't able to answer the committee's questions. But as a result of some further changes that happened right around 2012, we made several reporting changes, and now we collect the very data that the Transportation Committee wanted, and they found that to be somewhat useful. I will say that was a pretty significant undertaking in order to do that. There were costs associated with it with our vendor, where fortunately the Bureau of Highway Safety was able to fund some of that with their funding and some of it with grant funding in order to do that. I think that was probably the last most significant data collection bill type thing that I can recall that has happened in my career in law enforcement.
Thank you, Major. Thank you, Madam Chair.
You're welcome. Major, I wanted to ask one follow-up question regarding that. Does the Maine State Police have an electronic record system?
Thank you, Senator Carney. So the answer is we do have an electronic records management system. However, the Maine State Police does not have an electronic warning module. We currently use eCitation. I had mentioned that during our public hearing. That is a product where it's been built by the Bureau of Highway Safety with their monies. It's available to all law enforcement agencies. It's got a facing portal, web access for a law enforcement agency, and the Maine State Police uses that right now in order to submit all of our traffic violation data. So only if we issue a summons do we use that system. There's no warning module currently contained within that system. And we also don't do reports on every traffic stop. So I had mentioned earlier some of the numbers. So this is a reason why we have not in the past. If we were to include a report, see, if we issue a traffic summons, we collect the data that's on the summons itself, and that gets issued to the Violations Bureau. So we have that information and we save that, and we make officer notes on the back in case we need that for a court proceeding down the road or potentially for a hearing at the Bureau of Motor Vehicles. But we don't enter that into a system. So we don't capture any of that data. To capture that data, thinking of 75,000 stops a year, even if that were somewhere around 10 minutes a report, that's about 750,000 minutes or so, or 6 full-time employees in order to do that. So it'd be really time consuming in order for us to do a report for every traffic stop. That was just for the citations that we, I would think that e-citation.
Yep. I think you answered the question. Thank you.
Thank you, Senator.
Yeah. Representative Harnett, go ahead.
Thank you very much, Madam Chair. Nice to see you again, Major Scott. As you were having the conversation with Senator Keim, I was trying to write notes, so sometimes I'm worried that I missed something. Did I hear you say that a judge might have to release exculpatory evidence if that was identified in records that were maintained?
So Representative Harnett, that in response to Senator Keim's question when she was asking whether or not exculpatory information, if it was contained within this data, would be released by a judge, I think the answer is yes, it would. I think prior to that, it may very well be provided by the prosecutors out of their obligation to provide Brady Giglio information anyhow. But that was in response to a question specifically, could a judge order exculpatory, and absolutely a judge could and should order exculpatory information to be provided.
And you would agree that the release of exculpatory information is one of the bases of our criminal justice system, that is the job of the prosecutor and the role of the state to release that whenever and wherever it exists. Is that correct?
Absolutely, 100%, Representative Harnett.
Thank you.
Representative Hagan?
Thank you again, Madam Chair. I have a little bit more for questions based on testimony. In one, I copied and pasted testimony earlier. This bill would require the officer to use their observation and perception to determine race, color, ethnicity, gender, and age. Officers do not have the ability to accurately determine a person's ethnicity and race just by looking at them, and that data is not currently captured on Maine driver's license. So my question is, in your meetings with lawyers, other law enforcement agencies or groups, is there a more fair way to judge the above mentioned perceptions of asking and info on a license may not be acceptable in the officer retrieving this information? It's a similar question I asked her, the professor.
Thank you for that question, Representative Hagan. Sorry for the leaning in. It's a little hard to hear. I've got my laptop with me and my volume is as loud as it goes and I'm struggling.
I'll use my teacher's voice on the next one. I'll use my teacher voice in the next one.
Okay, thank you. That was a little louder that time. So as far as I talked about this a little bit during my testimony as well. There's always concern when you're asking for law enforcement to use their perception as to certain things, in particular, race, color, and ethnicity, gender and age are being asked in this data collection bill. So race, color, and ethnicity is not on a driver's license currently. So the officer's perception may be inaccurate. So I've got concerns with that. But I also know from experience of our agency and myself as an officer is, 60, 70, 75% of the time, I don't know the identity or have not even had an opportunity to observe the driver prior to the stop. So part of the concern that I was bringing up during the testimony this is about law enforcement behavior or implicit bias or bias that you stopped a motorist because of the color of their skin or their age or their gender or for one of these other categories. It is, if you didn't see them to begin with, then you certainly didn't stop them for that reason. Now, I heard it was Professor McDermott that was mentioned, and there's other ways to do it, like post data collection, and maybe that would be more accurate because at that opportunity, obviously you've had a chance, or the officers had a chance to interact with the driver, and you would see the driver and you get credentials from them, which may provide some of the information that you need on the ID itself, but also you have an opportunity to view the driver and you could form an opinion. It's challenging. I think we could say that someone is Caucasian or a person of color, male or female, generally speaking, young or old, but to define what that race is, to define what that ethnicity is. I don't think we're going to be able to do that based on officer perception. So I'm concerned if it's not good information that you're later trying to make good decisions with, are you going to make good decisions if you don't have accurate information? So I do have concerns with using the perception of the officer. One of the suggestions that came out from Maine chiefs, and I had talked about it a little bit as well, is maybe you do collect this data from driver's licenses. I did hear what was said earlier. I think it's an option. Right now, there is not a field on a driver's license for race or for ethnicity. So that's something that would have to be created, and it would take time. You know, driver's licenses in Maine are good for 6 years. So by the time you go through a renewal process and update that information, you could be several years waiting for the information. So I understand that that might not be an ideal solution. However, if a law enforcement officer is doing post-stop data, and they're determining based on someone's driver's license what their race and ethnicity is, my guess is it will be more accurate.
Committee members, I just want to take a little break here. And it seems to me that we are reviewing a lot of the same testimony that we heard at the public hearing. And if there's information that we'd like Major Scott to present that wasn't offered at the public hearing, and also that is needed by committee members to make up your mind as to how you're going to vote on the pending motion, then we can proceed with additional questions. But if committee members are not asking for new information and also don't need additional information to cast their votes, then I would suggest that we move on to a vote. And so I'll check in with, I don't remember who was next, Senator Keim or Senator or Representative Hagan. Senator Keim, is there a question that you need to ask to elicit information to determine how you're going to vote on the pending motion?
Yeah, something just came to mind that I think is important that at least gets brought up before the vote. And that, Major Scott, you mentioned that on another data collection bill that was heard, I think, last session, separate from this, that I think you said it would take 6 full-time employees for the time it took for the other bill. Was that right, or was it for this bill?
So Senator Keim, no, the last data collection piece regarding the main crash reporting did not take 6 full-time employees. What I was referring to is if we actually did reports on every traffic stop for the Maine State Police, that it would be about the equivalency of 6 full-time employees in order to do that. So
this bill then would take about 6 full-time employees to implement. Is that what you're saying?
Not entirely, Senator. Sorry. I was speaking about the 75,000 total traffic stops that the Maine State Police does annually in order to do reports on those. If we were talking about the 30 seconds to 2 minutes, which I don't know how long this will take, but I did hear Professor McDevitt say that he thought it would take 30 seconds to 2 minutes. If that were the case at 75,000 stops per year, that's about 2,500 hours total. That's over 1 full-time employee.
And that's if it takes 30 seconds?
I was figuring if it took 2 minutes on the outside.
2 minutes. Okay. One employee. Okay. So what my question is, and this actually may not be a question for you, but it might be a question for Peggy. So what my question is isn't this then a mandate if we are saying that that all of our local police law enforcement agencies have to do this? Wouldn't this bill then become a mandate unless we fund every department the cost that this will be?
So, Senator, I believe the answer is yes, and we did start working up some costs just for the Maine State Police for an e-citation warning module. It's about $175,000 for the module. We'd have to have that refreshed because our vendor provided that to us about a year ago, and about $35,000 annually for maintenance for just that system. The state police already have access to it, so we wouldn't have additional cost, but other law enforcement agencies would have cost. There's a certification process to make sure that they can get into the system that's credentialed with multi-factor authentication to protect data, to make sure that it isn't, easily hacked or obtained by someone who shouldn't have access to it. So yes, there would be a cost. I don't know what that would be. There's around 160 police agencies in Maine, and my guess the cost could be pretty significant in order to allow them to all have access to the system.
And we would also have to fund the cost of the collection, like the time as well. Is that right?
Senator, if we were asked for a fiscal note, I think we would include that
Okay.
in our fiscal note. Yes.
Okay. All right. Thank you so much.
Representative Talbot Ross.
Thank you so very much, Madam Chair. I just thought I'd just add one little component, which was the Attorney General testified that he would seek Second Chance Act funding, federal funding, which he felt was quite accessible to the state in order to absorb any costs for implementing this bill. The Attorney General went on record indicating that he would aggressively pursue the funding to take care of any additional cost that may be occurred. Thank you.
Thank you for contributing that, Representative Talbot Ross. And I know that, Representative Hagan, that you have your hand up. Again, I feel like we are simply reconducting the public hearing on this matter. And I would just ask if you have not decided how you are going to vote on this bill and you have a question that was not covered in the public hearing, please proceed with asking it. And then I feel that the committee should move on to a vote.
Thank you very much, Madam Chair. I know at the public hearing, it's a great fact-finding gathering thing. It's wonderful. What I have is questions for the work session in order to help my vote. I have thought up clarifying questions in the aftermath of the hearing that I couldn't have asked because I didn't know some of the information. So I only have one more question that pretty much it could be for the major, but it could also be for someone else. Okay to go ahead?
Yes, please do.
Thank you very much. So my question is, and I don't really know where I'm going with it, but it was piqued from that hearing, is the people that are in the vehicle, the passengers. I fail to understand so far for the bill why, from what I gather, the bill says that we have the officer who pulls over the vehicle has to do a report on all passengers. And I'm curious as to if these passengers have not done anything wrong to warrant a police stop, perhaps why all of them, which is time consuming depending on how many people are in the vehicle. And if there's nothing for them, why would they be included in a report? That's all I have. Thank you very much.
Representative Talbot Ross, is that a question that you could answer for us, please?
So thank you, Madam Chair and Representative. The way that the bill reads is that we would be collecting the data of the person stopped and the outcome of the stop. I
Perfect.
Only
I
can
appreciate that. I misread it, hence my question, and I do really appreciate that answer. Thank you very much.
Yeah, thank you both for clarifying that. Representative Talbot Ross, I actually had one other question for you. This was something that I think Representative Moriarty brought up at the public hearing. The use of the word on, let's say, page 1 of the bill, line 22, and it occurs other places. It says the following information regarding traffic violations. And should that be traffic stops or traffic infractions or some other word? Because it could be a stop that does not result in the issuance of a ticket.
Thank you, Madam Chair. Yes, that is correct. I think that was a great point by Representative Moriarty. And I think at one point we had talked about this, making sure that that was corrected, that was well understood. So I appreciate you bringing that up, and to the great representative for calling it out originally. Yep, thank you.
And can you just remind me if, actually, let me just turn to Peggy first. Peggy, do you know, did we have a suggested replacement for the word violations?
So the term, the defined term is traffic infraction in Title 29A, and it's a civil violation. And so I think that's what you're looking for, because you're looking for when a law enforcement officer stops somebody for, I think it's a traffic infraction. It's not that they're stopping them because they think they engaged in a burglary, but it's a traffic stop. And so I think you stop somebody because you think they've committed or engaging in a traffic infraction. And I hope Representative Talbot Ross will correct me if I'm okay. So I think the correct terminology is traffic infraction, and somebody is stopped for a traffic infraction.
And from the your perspective as our policy analyst, would you replace the word violations with the word infraction throughout the bill?
I would. Because
And so
I think that's what the focus is, and traffic infraction is a defined term. Traffic violation is not a defined term.
Thank you. And Representative Evangelos, would you consider that a friendly amendment to your motion? So we're hearing, getting the literal thumbs up from Representative Evangelos, and that motion was seconded by Representative Sheehan. And is that also acceptable to you, Representative Sheehan?
Yes, thank you.
Okay, thank you. Okay, and so the motion pending before the committee is ought to pass as amended with two amendments. The first is the amendment that was submitted at the time of the public hearing, which is to strike paragraph number 2 of section 4754 on page 2 of the bill. That's lines 21 to 27, excuse me. And then the second amendment is the replacing the word violations with infractions. Is the committee ready for the vote? It appears that we are, and Sufi, thank you very much for being present to take the vote on LD 132. It's an ought to pass as amended motion, and you can proceed whenever you're ready.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I shall call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Newell. Representative Newell is absent. Madam Chair, I have 7 members voting in the affirmative, 5 members voting in the negative, and 2 are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And could those who voted against the motion, please state what your report on the bill will be?
Right, ought not to pass.
Thank you very much. And so the motion carries 6 to 5. And no, I think that was wrong. Soupy, what was the vote again?
7-5.
7-5.
I had 7-5.
Thank you. I miscounted. The motion ought to pass as amended, carries 7 to 5. And with that, we'll close the work session on LD 132. Committee members and Peggy and Soupy, would you like to take a 5-minute break? We've been working since 1 diligently. So I'm seeing some nods. So let's reconvene at 3:30, please, everyone. Okay. Committee members, if you have returned to your desks, could you please activate your video so that we can resume our public hearings? Thank you, everyone, for all of your hard work on the previous bill and for returning after a short break. I know it's hard to keep plugging ahead. I'm also having a thunderstorm at my house, so you might hear a lot of noise in the background as we proceed to our next bill. So the next bill we have is LD, I'm just going to put on my reading glasses here, LD 952, and this is an act to limit liability regarding donations of menstrual products. And Peggy, do you want to give us a very kind of top line bill analysis, please?
Sure. So this bill actually tracks the food donation statute in our law that allows a limitation of liability. So for anybody who donates or who receives and then passes on, in this case, it's menstrual products, as long as they are apparently usable. And apparently usable in the statute, in the bill, is defined as the product meets all quality and labeling standards imposed by federal, state, and local laws and regulations, even if the product may not be readily marketable. And so if it meets those requirements, then neither the donor nor the charitable or nonprofit organization that receives that for free distribution is liable for civil or criminal liability from injury or death due to the condition of the menstrual products, unless the injury or death is a direct result of the gross negligence, recklessness, or intentional misconduct of the donor. Or of the organization, employee, or the volunteer.
Thank you.
And there's actually a slightly different immunity provision for the healthcare facilities, hospitals, and other healthcare facilities. They would only be liable. Same thing applies, but only liable for if the injury or death is a direct result of intentional misconduct of the donor being the healthcare facility.
Mm-hmm. Thank you very much. Anything else you wanted to add?
I don't think so, but I'm happy to answer any questions.
All right, let me just turn to committee members. Committee members, are there any questions for our analyst, Peggy? Go ahead, Representative Babbage.
Yeah, thank you, Madam Chair. Peggy, just because this part of the law doesn't deal with the manufacturer, that omission doesn't, by extension, imply any immunity, right?
Well, the manufacturer could be a donor.
It could be, but if it's not,
right,
you know what I'm
then it
saying?
wouldn't. So if it's a store that is donating inventory, then you're right, they wouldn't be, that wouldn't be a party that this cover, the manufacturer wouldn't be a party that this covers.
Would not, thank you, yeah.
Right, but I know there was a question raised at the public hearing about, well, what if it's a defective product? What if, and I think that's answered by the definition of apparently usable. If it's a defective product, then I'm assuming it does not meet all the quality and labeling standards imposed by federal, state, and local laws and regulations.
Concern would be a chemical, no.
Right. If there's some kind of, alien substance in it, then I would think that would not meet the federal requirements.
Okay, but this bill is about the donor anyway, so I did not want to excuse the manufacturer inadvertently, that's all. Yeah.
Right. So it's about the donor who gives it to the charitable or nonprofit organization, but it's also about the charitable organization who's passing it on to the individual user or recipient.
All set, Representative Babbage? Representative Hagan?
Thank you, Madam Chair. Just a quick one. It said fiscal note to be determined. Has it been determined?
I will double check, but I don't think that's available yet. Nope.
Did you have any follow-up, Representative Hagan?
Yeah, thank you. Well, not really a follow-up, just I was curious as to when that might come out, or if it's going to come out, and who would send that
Well, the Office of Fiscal and Program Review.
before the big vote.
Right. The Office of Fiscal and Program Review is responsible, actually under the joint rules, to prepare a fiscal note. So they will look at it. They're busy, so they definitely, you voting on this bill would trigger them working on that. They're working on it now, but it would make them put it up to the top of the pile. If it's something you need before you vote, then we can request it.
Nope. No, I appreciate it. I was just curious. Thank you.
Representative Moriarty?
Yes, I will move ought to pass.
Thank you. We have a motion from Representative Moriarty ought to pass. Is there a second on the motion? Representative Babbage, is that finger a second? Yes. Okay, so a motion ought to pass by Representative Moriarty, a second by Representative Babbage, and I'll turn to the committee now for discussion on the vote. Representative Thorne, go ahead.
Yes, I just wanted to come back to Representative Babbage's question, which I think was addressed in the public hearing about what if the donor was the manufacturer? And there is, and I think what the line that says it is on line 11, immunity for donor. And the first line comes out and says, notwithstanding any other provision of law. So, I think that kind of entails no total immunity if it's a manufacturer defect. That's how I interpret that. I could be wrong. Peggy maybe could answer, but.
So I think that actually that it's good you point that out. The notwithstanding of any other provision of law means this law really controls liability. But what I think when you're talking about product liability or a manufacturing problem, that's going to come into the definition of apparently usable. So if it doesn't meet those requirements, if it's not, the only thing that it doesn't have to be is readily marketable. So it might have odd labels on it, or it might still meet all the requirements, but might be a different color or something, but it meets all the safety requirements. A defective product, I don't think meets those safety requirements, so wouldn't fall under apparently usable. So this wouldn't even apply in those situations.
Okay, great.
Representative Babbage?
Yes, Peggy, tell me if I'm wrong, but what the apparently usable standard could be different for a distributor than it might be for the manufacturer. But I would think that the gross negligence, recklessness, or intentional misconduct would cover what I'm after, because I'm thinking, okay, the manufacturer has created a defective product that is not visibly recognizable, but they want to dump it in a donation because they don't want it out there for other purposes. And that's where I would want to protect the recipients of the donation if in fact there was negligence or recklessness on the part of the person. And I think this statute does that. Isn't that what we're?
It definitely says there's no immunity for gross negligence, recklessness, or intentional misconduct. So if they know that there's something wrong with it, and that's why they're making such a generous donation,
right?
Yeah, that this would not apply.
Thank you.
Or it wouldn't apply. Give them immunity.
Yeah. Yes.
Right. It would not give them immunity.
Thank you.
And let me just check in. I know that I brought the bill sponsor over from the attendee portion of the meeting, but I also know that she often is pulled. Oh, Senator Breen, thank you very much for joining us. I just wanted to give you a chance to address the committee if you wished to speak on this bill.
Thank you so much, Madam Chair. And I don't vote on this committee, but I would support Representative Moriarty's motion. And I thank you all for the work you've been doing on it. And I'm available for your questions if you have any of me, but otherwise I'm just here to, just be a resource.
Thank you very much. Committee members, are there any additional questions for our analyst? Are there any questions for the bill sponsor? Is the committee ready for the vote?
Yes.
Sounds like people are. Great. Thank you very much, Soupy. And Senator Breen, thank you for being here today and joining our work session. And so the pending motion is ought to pass on LD 952. And we are ready for the vote, Soupy.
Thank you, Madam Chair. Representative Babbage has his hand up. Nope, just want to make sure.
Thank you for checking.
Thank you. Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And the motion passes 11 to none with 3 absent. And with that, we'll close our work session on LD 952 and move on to our next bill, which is LD 986, an act to provide campground owners unlimited civil liability from the inherent risks of camping. And I know we're changing gears, Peggy, and whenever you are ready, we are ready for your bill analysis. Thank you very much.
Thank you. So this bill is a little bit different. It's also extending immunity. It defines inherent risk of camping to be quite a long list of things that you could look at as whether they may or may not be natural features. And it provides that basically in dealing with a private campground, a visitor or a customer or a camper at the campground, it says may not maintain an action against or recover from the private campground owner or its agents for any losses, injuries, damages, or death that result from the inherent risks of camping. The exemptions are if it doesn't apply if the person claiming the limitation, so the campground owner or its employees, intentionally causes injury, death, or property damage, acts in willful or wanton disregard for the safety of the party or property damage. That's probably equivalent to recklessness, or fails to post or provide the warning that the statute requires. In one of the things you asked for was the rental agreement that Ms. Winship, I think, sent to you from Papoose Pond, and that's starts on page 11 of the bill analysis. But you also asked about other immunity laws in the statute that provides some limited immunity for different recreational activities. So I've included those in the bill analysis as well. There, I know it's been mentioned that ski areas, and it's really interesting because it is in the tramway regulatory law, but the liability, a ski area operator or its agents, representatives, or employees are not liable for any loss, injury, damage, or death resulting from the design of the ski area. And it also includes an assumption of risk in the statute for skiers. This section does not prevent the maintenance of an action against a ski area operator for negligent operation or maintenance, or the negligent design, construction, operation, or maintenance of a passenger tramway. So the discussion at the public hearing was a little bit about whether these are immunizing folks for their negligence. This is not, in the ski law doesn't immunize the ski area for negligence. Agritourism is there, equine activities, and I'm not sure, people were talking about the snowmobile liability, and I'm not exactly sure what that is, other than maybe it's the landowner liability for recreational activities, where it immunizes the landowner for letting people use their land to engage in recreation or harvesting activities. I'm going to stop there, and because I'm talking too much, and you can ask me questions or you can go on to the next thing.
I'm muted. I have to say to myself, you're muted, Anne. Thank you very much, Peggy. And I see Senator Keim has a question. Go ahead, Senator Keim.
Thank you, Madam Chair. Peggy, so I know that you mentioned the other ways that we've provided limited liability, like to ski areas. Is this very different from what we're doing for equine or ski areas, or is it pretty much in line with that?
I think it's kind of a mix. Because it's a mix in that the list of things that are inherent risks of camping. So first of all, a campground owner shouldn't be liable for things for which they're not negligent, or reckless, or grossly negligent, or do intentional misconduct. But they shouldn't normally be held liable for anything that they're not negligent about. But in the list of inherent risks of camping, it includes piers, docks, swimming and aquatic sports or recreational facility areas. So some of those are, human made and maintained. And if you're saying that the dock is an inherent risk of camping, then you might be immunizing them from more than that. I mean, it does say intentionally causing injury, acts in willful or wanton disregard. But if there's a negligent maintenance of the dock, then this would be immunizing them for that, I believe, the way that's written. I'm not sure how lighting plays. If I mean, I understand that when you go to a campground, you don't expect it to be there to be street lights. I'm not sure if there are places where there is an expectation that there needs to be lighting. And I think playgrounds, these are just the three things that jumped out at me. That playgrounds would be something that you would expect somebody to maintain to a pretty high level of safety.
And then, so similarly, to draw a comparison and help me understand, with a ski slope area, we're not exempting them from the lift, so to speak, right? Like drawing a comparison, we're not listing their lifts.
Right.
Is that right?
It specifically says, yeah, they're not, let's see, are not liable for any loss, injury, damage, or death resulting from the design of the ski area. So that's what the exemption is for. But actions are not prohibited for negligent operation or maintenance, or negligent design, construction, operation, or maintenance of a passenger tramway, which is the ski lift, right?
Okay. And I was looking to see if the bill sponsor was here and if there would be an amendment that would be more in line. So I will check that. Thank you for those answers.
Yeah, and Senator Keim, I had too, when we started the work session on this bill, I looked and I did not see the bill sponsor here either. I would have brought him over. And if he shows up, I'll bring him over. Representative Thorne?
Thank you, Madam Chair. And I think we established this in the public hearing, Peggy, but if something was found to be in disrepair, like a rotten board on a wharf or something that wasn't maintained properly, that it didn't exempt in that case because of the wording of limited civil liability. If it was deemed, and I think it was, I have my notes here, Taylor Asen, that said willful or intentional. You know, in other words, if they knew that the board was rotted or weak and it had to be replaced, kind of like how towns, you hear about towns that have a big pothole and somebody hits it and reports it, and if somebody else hits it after they report it, then it, you know, falls under their no immunity. They're liable for it because they didn't repair it in a timely manner. And I don't know if there's a provision in there that specifies if it gets inspected or identified at some point. That's kind of an open-ended question, but.
Right. So I'm not sure if I can answer that other than to say, absolutely, if this, I don't think this would immunize a campground if they have a playground and they know that it's falling apart and they don't do anything about it and somebody's injured.
Right.
Because you're right, that's willful or wanton disregard. I think that's recklessness. You recognize that something can happen and you don't do anything about it.
Right.
What I think it does immunize is negligence in maintaining the playground. That they're not checking it on a regular basis. The same with the dock. I think a lot of the other things are absolutely inherent risks of camping that you don't control. A campground owner doesn't control these things. But I think there are some things that somebody could be negligent in providing it. And I think this would immunize them, wherein if this law weren't in existence, they wouldn't normally be held liable for most of these other things anyway, unless they were negligent.
And I hate to mention an aside, but I mean, do insurance companies inspect campgrounds for safety violations? Or, you know, kind of like the same way that if you're a homeowner and you have a trampoline in the backyard and you don't report it to your insurance company, and your insurance company finds out about it, they can cancel your insurance. Or are we at just, that's a whole different aside.
Right. Well, I think this bill applies whether there's insurance or not. And I think that I'm sure insurance companies appreciate statutes that provide some sort of liability protection to their insureds. But I also think insurance companies don't want to write policies when they don't know what the risks are, or they at least want to know what they're writing the policy to cover. So if they're covering a campground, they probably have something in their contract that either says we're going to inspect, or you have to maintain it to a certain level.
Right. Thank you.
Hey, Peggy, I wanted to ask you a question about Title 14, Section 159A, the limited liability for recreational and harvesting activities, because it seems to me that that already covers camping, and that the policy kind of encompassed in that statute is that camping activities are going to be immune from liability for negligence in the non-commercial setting, but where a company is operating a camping business and accepting payment for providing facilities like the dock and the boats and the fire pits and all that stuff, that those companies are going to be responsible to their customers for negligence.
Right. I don't think Title 14, Section 159A is intended to apply to commercial operations. It's letting somebody come on your land to pick wild mushrooms or, raspberries, or if you let them come on camp, that's okay. Fishing, hunting, I mean, it's really what keeps the Maine outdoors accessible, is making sure that the landowner is not going to be held liable for anything unless the landowner knows there's an obvious danger, and then they do have to warn or block it off. So it's not intended to apply to a campground where people pay to stay.
Thank you. I just want to welcome the bill sponsor, Senator Timberlake, to our committee, and ask committee members if you, well, first of all, Senator Timberlake, did you wish to say anything to the committee at this point?
Yes, thank you, Senator Carney, Madam Chair. I really appreciate it, and it's always good. I never testified in front of this committee much in my 13 years here, so I must have been a good boy or something somewhere along the way. I think the thing that I want to point out in my intentions with this bill was, I think most of you know me as an apple grower out of Turner, Maine, and I wanted this bill to be more like the ag tourism bill in the ski bill. I'm not looking to make my family, we have a big pick your own, and we have a playground and a petting zoo and all that stuff. And that stuff is not exempt. If you're over to the place and you come in and you're playing in the swing set or on the pirate ship or crawling on the tractors and stuff, you know, we ensure that. But if you're walking up in the orchard and you trip over a tree root when you're picking apples, or walk into a low hanging branch on an apple tree, or if one of your children misbehave, probably like I would have when I was younger, crawl up in the tree and fall out of the tree, you know, and gets hurt or something, or they get stung by a ground hornet's nest or something along the way. I looked at it as more of trying to do those things, that when they're at a campground and they're walking through a trail, and, you know, I've been to some campgrounds where they had some big, you know, pine trees, and there's pine roots that stick up, and somebody trips and stumbles over the pine root or something because they didn't have them all chopped off flush to the ground or something. I looked at it as more of that, not so much about docks and the playground and that stuff. I looked at it as more of inherent things that had to do with just keeping a campground somewhat like the environment, the woods area that it's in, and not being part of, you know, the dock, the boat, that type of stuff. I'm not looking to exempt any of that because I don't think that should be. But that's what I'm thinking, and that's what I'm looking at it as. I look at the same thing as we did with the ag tourism exemption. So that would be the comment that I'd make, Madam Chairman.
Thank you very much. Committee members, are there any additional questions for Peggy at this point or for the bill sponsor? Representative Harnett?
Thank you very much, Madam Chair, and thank you for joining us, Senator Timberlake. My concern with this bill, and you just identified a lot of them, was how broadly the bill defines the inherent risks of camping. And it does include a lot of things that I don't consider necessarily camping related: piers, docks, aquatic sports, recreation facilities, swimming pools, water slides, boats, canoes, boating equipment, playgrounds, and other sporting equipment. Would you be amenable to removing sections 64-C, section B, 3 and 12?
Representative Harnett, if I had that in front of me right here, I was just getting ready to head, and I don't have it in front of me right now, so I'm going to be honest with you. But I will tell you, Representative Harnett, I am amenable, I get my tongue going the same direction, to an amendment to those sort of things. I'm looking to make this, you know, in my feeling, if they were swimming in the lake or on a pond or on a river, you know, and it wasn't one of those with the buoys around it, then that would be the same as walking through the woods with the tree roots. But if they was in the swimming pool and thing, I think there is, you know, that's their responsibility to take care of that and make sure that that's maintained. I think, Representative Harnett, we're talking a lot about the same things. But I don't have it in front of me, so I can't honestly answer that. How's that for an honest
I appreciate
answer?
that. I appreciate that. Thank you.
Representative Babbage?
Thank you, Madam Chair. Good to see you, Senator Timberlake. And I wanted to share with you my thinking on this and give you an opportunity to know that and respond if you'd like. We did hear testimony that inherent risk is covered if in any technically in any business really, if reasonable care has been taken by the owner. And that if that is true, I mean, I don't think we're going to stop, even with this bill, I don't think we're going to stop lawsuits. We might stop successful lawsuits, which is what I'm sure you might be after. But the comment was that the coverage is already there for that kind of inherent risk. And my concern would be that would the reasonable care standard then be lowered as people are doing their spring checkoff lists as what needs to be done? I mean, if the dock has a couple of bad boards, or if there's a major support that needs to be replaced, and that's a pain in the neck. Well, maybe we'll put that off another year. Whereas a reasonable care standard says, no, that's going to be a priority this time. So I wouldn't want to lower standards by offering immunity. And that's where I'm kind of coming from. I just wanted to share that.
And Representative Babbage, I thank you very much. It's a great question, but and I'll attempt to answer it. I think everything you've said is truthful. I'm not looking to exempt the campground owner from not replacing the board. I think he should replace the board. I think he should fix the things that would be an inherent risk. I'm looking at more, and I'm talking to a guy who buys insurance for my ag tourism industry, okay? And this is what I can speak about, because this is, I don't know if I call myself an expert, but I've been doing this. I'm an 8th generation farmer, and we've been doing this for like 40 years now. But I am exempt, which has made a big difference to our insurance company of the child falling out of the apple tree, the child tripping over the tree root, or stepping in a groundhog hole in the orchard, or having an apple fall out of the tree and hit them between the eyes. You know, there is an awful lot of things that in today's society, in today's world, that people sue you for. And if you can cut down a percentage of them, Representative Babbage, you can lower your insurance rate. And if the insurance company can look and say, okay, by passing this bill with these limited things that I think everybody here makes sense, that I can lower your bill by 10%, or maybe this year it doesn't jump by 20%, and the campground owner doesn't have to close or move on, because insurance rates, as you folks all know, have gone through the roof in the last 5 years. And anything we can do to help with that and cover what I call the easy stuff, the stuff that makes common sense, I think we should do it. And I think that's what I'm asking for. Now, the bill, when it was put out, was given to me, just like all of you guys have sat around here and had different organizations give you a bill, and you put it in, and then you say, okay, here's our starting point. Now let's work this bill and figure out where every committee, you guys are the experts. I'm not. You know, if you was at Ricker Hill and we was talking about farming up there and what you needed to do to grow apples, my God, I can give you a heck of a lot of advice. But when it comes to what you got to do in this committee, I can't do that. I can give you what I think is common sense and what makes sense to me. And that's what I'm doing. And I'm saying that I'm very amenable to an amendment to this bill to make it so hopefully we can lower the cost to the insurance rate, to the campground owners from the insurance companies by a percentage. What is that? I don't know. But I think we should create a starting point that says these things, this is good and this is bad. I don't disagree with you. I don't want you to forgive the guy with the broken board. You know, because it'd be my luck, I'd step on it. I'd fall through it and twist an ankle, and I'm old now, so I'd fall off and then bang my head on the pipe and probably drown before I was done. So, but thank you.
Okay, thank you.
Representative Moriarty, I know you have a question, but I just want to jump in and ask Senator Timberlake, I appreciate that you're trying to kind of balance out a lot of different interests. And to me, as I look at this and I look at that agritourism immunity bill and the limited liability for recreational activities, I kind of feel like all of the matters for which our state wants to grant immunity are kind of covered by those bills already. And I sort of simultaneously, while I appreciate your concern about wanting to reduce insurance costs for business, I think that there's kind of a countervailing concern about excusing a business from premises liability if somebody, through no fault of their own, but through indeed the negligence of the business, is injured on a business premises. And I personally kind of feel like our law already balances that, where we've got the agritourism immunity and the recreational activity immunity. And I'm just trying to understand where you would want us to go with an amendment that would maintain that balance.
And thank you, Madam Chair. I think what I'm saying is because a campground owners, they charge for the use of their land and their property, they become a commercial organization. And I would like to see them treated the same as the ski industry is, which is another commercial organization. But they've created some things that says skiing has some inherent risks and you can't sue for these risks per se. And I would like to see the same thing, that camping has some inherent risk. If you walk through the woods and you trip, or you climb the pine tree and you fall out of it, if you build a bonfire and you pour gas on it and the fire flashes back on you, you know, these are all stuff that, yes, probably if I go to court, I win. But in the meantime, I had to spend all sorts of money defending myself to get to court, and hiring the insurance company, had to hire the lawyer. And it's amazing what that sign I hang on the side of my building that says, we're not liable for you having an apple fall and hit you, or tripping over the thing, for stepping in a groundhog. People walk away without that lawsuit. It's really helpful in discouraging that, Madam Chair, in the first place. And I think that's what I'm looking to do, is to stop them from running down in hiring the lawyer in the first place to come try to sue them, and then they have to defend themselves and say, these are the things that you shouldn't even be talking about suing us for. These are things that are inherent risks to camping and at a campground. These other things that Representative Babbage talked about are not inherent risks. That's something the campground owners should be responsible for. You know, that should be fixed. The board should be fixed. The dock should be made safe to walk on. You know, those things are all things. A swimming pool should be safe to swim in. You know, those things are all there. But the actual, just the things that go inside a campground that have risk that people still sue you for today because you didn't fill in the woodchuck hole. Well, you didn't see the darn woodchuck dig the hole in the first place, and you didn't know then, you didn't know anybody was going to walk over there. You know, as a rule, you go try to fix those things. When someone comes back to me at the farm and says, hey, you got a hole out there and my son tripped over it, then I'll usually go down, find the hole, and take a bucket loader and go fill it. But these things here, I think you could just save some money and help everybody all the way around and keep businesses in the main going forward. So that's the way I feel, Madam Chair.
Yeah, and I guess I can appreciate your desire to save businesses money on insurance policies, and I agree with you on that. But I also think that, you know, where somebody is injured by a business because of the negligence of the business, that's you know, that's maybe not the right area where we want to try to save some money. So let me just turn. I see that Senator Keim has her hand raised. So let me call on her. Go ahead, Senator Keim.
Thank you, Madam Chair. I think where I would like to go with this bill is to see it amended to make sure that it's clear that nothing's included in there that would be the responsibility of a camp owner for upkeep. And so I think that I could vote in favor of a bill that gives clarity in the law to an industry such as we have for others by making some parts of it black and white. But I think absolutely we need to make sure that there is a path forward if any business owner anywhere is negligent, that we are not giving them any sort of limited liability. So I don't know how the committee feels or how they want to go about this, but I would be happy to vote ought to pass as amended and state that my amendment would take out anything in the bill that you know, like campgrounds and docks that clearly are the responsibility of the campground owner, and we could either table it and come back and look at the amendment later, or we could, if everyone's kind of sure how they want to vote, we could vote it and I could just bring the language back for language review. And if someone wanted to change their vote, then we could possibly do it then, but that might, those are two different options to sort of move the bill along. And I just wanted to state that as my opinion on one way to move forward with the bill and the way that I would like to vote on it.
It sounds like a pretty significant change and maybe something that would be difficult for committee members to vote on without actually seeing the language. And so I think my suggestion would be that you move to table it and then work with the sponsor to bring an amendment back to the committee. We can reschedule this for hopefully a more condensed version of a work session in a week or so, if that would be a way to proceed.
I think that sounds fine, but I won't make the motion until I think Representative Moriarty still has a hand up, and I just don't want to cut short someone by making a tabling motion.
Thank you. That's really considerate. Representative Moriarty, go ahead.
Thank you, Madam Chair. This may be moot in light of the last exchange, but I've listened to everybody and I wanted to follow up on Senator Kimes' comments. And I have two specific amendments to offer, which may address people's concerns. And they both involve some of the numbered subparagraphs in paragraph B titled Inherent Risk of Camping. One would be to delete subparagraph 12, which reads playgrounds or play or sporting equipment. And then moving back to subparagraph 3, I would suggest that it be reworded to say natural bodies of water and the use of natural bodies of water, such as wading and swimming, period.
May I ask Representative Moriarty a question? Oh, never mind, I'll put my hand up.
I think Senator Kimes' hand was up first, so, and then speak Representative Babbage. Go ahead, Senator Kimes.
Yes, thank you. Representative Moriarty, that's in line with what Representative Harnett said, and I totally agree with you. I just wanted to make certain that I wasn't, as I was quickly looking through the list, I saw those two jump out, but I just wanted to make sure that we weren't missing another, which is why I had said maybe we should table, just because I wanted to be certain I wasn't missing something, but thank you for that.
Sure, okay.
Representative Babbage?
Yeah, thank you. Representative Moriarty did say such as wading and swimming, I think he said. The such as kind of bothers me because what does it mean about use? You know, I do think equipment is a responsibility of the camp owner, and that would be use of the water that I think the representative is trying to separate from merely natural use of the water through wading or swimming. But that's one thing. And then I just need to make sure that the reasonable care standard is not abandoned in this. If I can be assured of that the camp owner is still responsible for reasonable care for the safety of, then I would be satisfied with being specific about some of these things that I don't think anybody intends. I mean, a hole in the ground, okay. But if it's a man-made hole that wasn't properly capped or something, that's definitely a negligence issue. So you know, we have to be careful once we start getting specific. So I'd need to see the reasonable care standard in there, I think. Thank you very much.
Representative Harnett?
Thank you very much, Madam Chair, and I'll try to be very brief. Many of my concerns are embodied in the sections that Representative Moriarty mentioned. And those are the ones I raised with the bill sponsor. But I support the tabling motion. I know we're not supposed to debate those, but we don't have the motion yet because I need to see what it looks like when it comes back amended. So that's the path I would prefer to take, no pun intended.
All right, so does anybody else wish to have any discussion before somebody considers making a motion to table? Representative Moriarty, did you wish to?
I'm ready to make a motion.
Okay. Is there anybody else who wishes to speak before Representative Moriarty makes a motion? Representative Babbage, is your hand residual? Thank you. All right, go ahead, Representative Moriarty, you are recognized.
Thank you, Madam Chair. For the reasons previously discussed, I move to table LD 986.
Is there a second? Senator Keim seconds. And we are going to do this. I think we can do the tabling motion in a show of hands. So let's use our electronic hands. All those in favor of tabling, raise your electronic hand and just leave it raised, please.
I have 11.
What I have.
And nobody against.
Madam Chair, just for my records, I know Representative Moriarty made the motion. Who seconded?
Senator Keim, and Senator Sanborn has not yet voted.
Okay.
Oh, you did?
Yes,
vote?
I did. I just put my hand down after the number was announced. I
Great.
apologize.
No, that's all right. I'm keeping a record as well. Okay, great. Thank you. So the tabling motion has passed on LD 986, and we'll move on to our next work session. Work session on 986 is closed. And I should put down my own hand. There we go. And now we'll move on to our next bill, which is 1254, an act shielding fire departments that install smoke and carbon monoxide detectors from liability. And Peggy, whenever you are ready, we're ready for you.
Okay, oops, am I? Oh, I'm not muted. So this would add a new section to Title 14 to provide immunity to or an employee or a member of a fire department that delivers to or installs at residential premises a fire alarm. It has to be a new device, has to meet all applicable current safety and manufacturing standards. The device or the batteries have to be installed in accordance with the manufacturer's instructions. And the installation or delivery is performed in the fire department's official capacity. It does not include the hardwired or the, the electrical smoke fire alarms. So the question was whether, I realized that Representative Pebworth said that there were fire departments that were interested in providing this service, and they were concerned that they would be liable. I'm not sure for what, if they engaged in this activity. So you asked at the public hearing about whether the Tort Claims Act applies to fire departments. And in fact, in Title 30A, there are municipal fire departments and there are volunteer fire associations defined. I think that covers the population of fire agencies, the fire service. And the Tort Claims Act defines employee and means a person acting on behalf of a governmental entity in any official capacity. And it includes volunteer firefighters, as defined in the section where it defines municipal fire departments and volunteer fire associations. So the municipal fire departments are covered by the Tort Claims Act, and volunteer firefighters are covered as an employee under the Tort Claims Act.
Could I ask you a question, Peggy? I think Maine Municipal Association raised a concern about whether, since these programs were not necessarily part of firefighting activities, that there might be some ambiguity as to whether the installation of smoke and carbon monoxide detectors were actions within an official capacity. Can you just comment on that, please?
Well, right. So the Tort Claims Act really covers entities and the people who work for them, public employees, when they are engaging in the scope, they're acting within the scope of their employment. The bill actually says the immunity applies, paragraph C of subsection 2, the installation or delivery is performed in the fire department's official capacity. So I guess official capacity, you can say that's a little bit different than official duties. Official capacity means I'm a firefighter and I'm doing this because my fire association told me to do this. So I'm doing this in my official capacity as a firefighter. Whether that is actually within the scope of their duties or within the normal definition of their job, I actually don't know. I guess if the fire department, well, you wouldn't want them to be able to totally define what they do.
Yeah, no, as you've been talking through it, I realized that I was not reading carefully enough. And I think that you have addressed it by pointing out to me that paragraph 2, capital C, does require the work to be done in official capacity. So you answered my question.
Okay.
Help me appreciate the need for not having an amendment. Thank you. Senator Kime, did you have a question?
So, Peggy, I'm in favor of this bill, but what you just said makes it seem like it's not necessary.
So the Tort Claims Act covers anybody, a public employee who's acting within the scope of their employment for any kind of negligence. And I don't think that you would be asking this to immunize anybody who's grossly negligent or reckless or engaging in intentional misconduct. So the Tort Claims Act, I believe, would cover the individuals as well as the fire department or the fire association. Subsection 2 says is not liable for damages for personal injury, wrongful death, property damage, or other loss related to the device. So if the device doesn't work, it's been installed and it doesn't work, this is saying the person is immune because they followed A, B, and C. And would that be true if you didn't have this law? Would the Tort Claims Act still apply? That's a little bit harder question because you're pointing to the device as being the cause of the damage or the injuries.
Okay. So it's questionable is what you're saying. Without this law, it's questionable whether or not the Tort Claims Act would just automatically cover this.
Right. I would have, think it would, but the fact that it's tying it to the actual device itself makes me wonder if there's a little sliver of possibility that somebody would be held liable there. I don't know, and hopefully somebody else who works with tort law a little more than I do would have an answer to that.
And then just my one other question, if I may, is does it change at all whether they're paid for this? Like if the fire department is paid to put these in, or whether they just do it as a community service to older folks or in certain housing or whatnot? Does that need to be addressed in the bill? Does that change it in any way?
So it says it's performed in the fire department's official capacity. So if the fire department is charging for the installation, I mean, maybe what they would do is ask for a donation. So it's still within the fire department's official capacity, as opposed to the fire department getting compensated for individual services it provides. I guess that would be a concern to me.
Right. Okay. Thank you.
Yeah, sorry.
I did want to welcome Representative Pebworth to our committee and to the work session, and ask you, Representative Pebworth, if you had any comments that you wish to make to the committee in connection with your bill.
Having me. I would suggest that Kate DeFore from MMA noted that the typical fire department duties of a typical fire department and firefighters do not necessarily include going into people's homes and installing devices. So because of that sort of gray area, that it might clarify things to add that this activity would be authorized by municipal officials, or that would be added in part 2 under immunity. And that would sort of clarify the absolute need for this rather than Tort Claims Act consideration. Something to consider.
Representative Pebworth, I also have been mulling over that suggestion. And would you think that it would be added like right at the end of subparagraph 2C? That the installation is performed in the fire department's official capacity and approved by the municipal officers?
Right, or as authorized and is authorized by municipal officials or officers. Officials, I might say. And I didn't know if it needed the weight of a full ABCD section D instead. But not the only one here who is not a lawyer.
Thank you very much. And we're so glad that you're able to join us for the work session. I think Representative Evangelos, I think your hand was up next. Go ahead.
Thank you. Thank you. I'm not sure it was, but I'll be brief. So if you make that change brings you right in line with the tort claims immunity law, because once it becomes an official duty of the fire department sanctioned by the Board of Selectmen or City Council, they're covered. I think what we need to consider is these small towns. The fire department does a lot of outreach and public service. Nothing's like official necessarily, but they put up a program that they'll assist people in putting a smoke detector in. If the people assent to that, I don't think the fire department should go soliciting, but if the people want it, this bill says to me, do no harm. And even if it's duplicative of current tort claims protections, it doesn't hurt anybody or anything, because no one's trying to hurt anybody here. So, I'm ready to move out to pass on this.
Is that a motion, Representative?
That is a motion.
Is there a second? seconded by Senator Sanborn. And Representative Harnett, your hand was up. I'll call on you next.
Thank you, Madam Chair, and welcome Representative Pebworth. And at the public hearing, I was the one who raised the issue, is this necessary because of the Tort Claims Act? And reading Ms. DeFore's memo, and if there's a hint of ambiguity, I'd rather resolve it. I am a little concerned relying on the words fire department official capacity in this section, because that would allow any fire department to redefine what their official capacity is. And that's not how the Tort Claims Act works. So I'm going to join in support of this bill. I do like the proposed amendment, and I don't know if Representative Evangelos would accept it, but I do like the role of municipal approval. So a department is not acting on its own, redefining what its official roles are for a municipality.
Is that acceptable to you, Representative Evangelos?
Well, what happens when the fire department and the selectmen are feuding, which is going on in a lot of towns, and read the papers. But I don't know. I just, if what everyone's telling me, and I don't have my bill file, all I have is Peggy's analysis, is the word official capacity in the current bill?
Yes.
Yeah. Okay. Well, then they're covered, but what I'm worried about is covering the small town operations. They're at the Saturday barbecue at the fire station, and hey, Charlie, can you come over and help me put the smoke detector in, you know, and yeah, we'll be over, how about next Saturday? You know, I mean, the stipulations that the selectmen and city council have acted on that, and I don't know, I think it gets complicated. I'll do whatever the committee wants. This bill needs to be moved. What is the desire of the bill sponsor, to include the amendment?
Representative Pebworth?
I think I would have to land on the side of MMA. I think that they have given sage advice in the past, and if that is helpful to them, then I might suggest including it. That would be my pleasure.
Madam Chair?
Yes.
Ought to pass as amended.
Thank you very much. And is that amendment acceptable to Senator Sanborn, who seconded it? All right, is the committee ready for the vote? So the vote is ought to pass LD 54 as amended, and the amendment is adding at the end of paragraph 2C words to the effect of and is authorized by the municipal officials. And with that, I think we're ready.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Yes.
Sorry, I was trying to unmute. Senator Sanborn votes yes.
Senator Sanborn, excuse me. Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
I'm sorry.
Yes.
Thank you. Representative Hagan votes yes. Representative Libby. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll call the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Libby. Representative Libby is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. The motion ought to pass as amended. Carries 11-0 to 3. And thank you very much to the bill sponsor, Representative Pebworth. And with that, we'll close the work session on 12:54 and open up our next work session, which is on LD 1066, an act to clarify the definition of mortgage servicer in the laws governing mortgage foreclosures. And Peggy, we are ready when you are.
Hey, great, thank you. So this bill amends the law that was passed just last year, 2 years ago, about holding mortgage servicers to a duty of good faith. And it turns out that in defining the terms mortgage servicer and servicer, what got dropped out of the requirement of dealing with good faith is reverse mortgage servicers. And so what this bill does is takes basically the definition of servicer and calls that the mortgage servicer and deletes the existing definition of mortgage servicer. So we end up with one definition, one term, which is mortgage servicer, and it applies in all these situations. And I'm thinking that's all that the bill does, but there was an amendment proposed over the last, there's been folks discussing, and they realized that there is a situation, and I must admit I don't have the email in front of me about all the details, but I sent the amendment out last night to change the definition of obligation to include a mortgage deed, even if the debt secured by the mortgage deed has been discharged in bankruptcy, because apparently that has happened where a mortgage deed has been discharged in bankruptcy, and yet the mortgage servicer has continued to try to collect and go after the mortgagor. And also in looking at the definition of servicing, which is what the mortgage servicer does, there's a list of 6 different activities that a servicer engages in. And it says servicing means any combination of the following, and it lists 1 through 6. Mr. Cox raised the concern that what if it's just one of those things that the servicer is engaging in? So can we change the word combination of to one or more of the following? So the mortgage servicer might only be collecting funds from a homeowner for deposit into an escrow account and making payments out of an escrow account. And if it says a combination, it makes it sound like the mortgage servicer would have to be doing at least one other thing or all of them. So that is intended to be a clarification. And then in talking about those actions, about what servicing means, number 6 at the top of page 2, taking any other action with respect to an obligation that affects the obligor's payment or performance of the obligation, or that relates to the enforcement of the obligation. And Mr. Cox, again, I know he's been talking to lots of different interested parties, recommended that change it to, or that relates to the enforcement of rights under the obligation. I'm sorry, I was supposed to update that amendment. It's supposed to be rights of the loan owner under the obligation. Is that what I sent out to you?
Yes, Peggy, that's exactly what you sent out.
But I have an old version. So that's a whole lot, and I was really hoping Mr. Cox would be here so he could explain those last little pieces.
And yeah, and he is not here, but if committee members have questions, I think we'll be able to work through them. Representative Evangelos, you had your hand raised?
Yes, a question for Peggy. Was the original intent of the bill last year, or last 2 years, intended towards the language you discussed regarding reverse mortgages and the like. Was this just to get a correction on the intent of the original bill?
Well, I don't remember talking about reverse mortgages. I think that the idea was to cover all mortgages. And I don't think anybody was really thinking about whether or not reverse mortgages were included in that. I mean, they were just assuming that if you're servicing a mortgage, you're servicing a mortgage. But because of the definition of mortgage servicer, which is crossed out, it's receiving scheduled periodic payments from an obligor, making or advancing payments to the owner of the loan, or evaluating obligors for loss mitigation. So that doesn't actually cover what a reverse mortgage servicer does, because they're actually providing, I believe, payments, or so that doesn't cover their activities.
Okay.
So I don't think it was intended to leave them out.
No,
I
no.
just think, right. I don't think anybody intentionally said, let's not cover reverse mortgage.
So are you aware if Mr. Cox produced the amendment in agreement with people who normally represent the banking side? Are they in concurrence over this?
I don't know. I must admit, I don't know. He was working with Senator Bailey, I know.
Okay, but he wasn't working with the attorneys who usually show up for the banks and stuff.
Not that I know of, but I don't believe this applies to the main banks.
Yeah. No, I understand. But I thought I was ready to make a motion, but the rest of your explanation, I'm in over my head now. And I'm
Sorry.
I hope Representative Harnett makes one, and I'll second it though. Thank
Oh,
you.
I did just get an email that Mr. Cox is available.
All right.
Let's see, I would love to be able to include him in this meeting. Do you know, Peggy, if he has a link to the?
I don't believe he does.
Okay, I can send him my link. He'll appear as Ann Carney, but.
Okay. I'm assuming he was listening, and so he will know he will appear as Ann Carney.
Representative Harnett, you can go while I'm taking care of.
I was prepared and still am prepared to make a motion, but I will wait till the committee hears from Mr. Cox regarding the amendment. I would just speak to the fact that there was no opposition to this bill from the reverse mortgage industry, and that is an industry that we know has been sometimes preying on elderly people in the state of Maine, and I think they should live up to the same good faith standard that traditional mortgage providers do. But I will wait to hear from Mr. Cox and then make the motion.
Okay. I am realizing that I do not have his.
Okay, that's great. I will send mine. How's that?
Thank you very much. I appreciate that. And so I'm sorry, I was multitasking. Did you make a motion, Representative Harnett?
I thought I would wait until the committee heard from Mr. Cox, but if I'll make the motion ought to pass as amended so we can have a discussion on that. So I move ought to pass as amended with the amendments outlined by our analyst.
Is there a second? Seconded by Representative Evangelos. And as soon as Mr. Cox appears in the attendee list, I will bring him over so that we can just confirm those points with him. I would like to say in debate on the pending motion, discussion of the pending motion, I think it's really important that we strengthen these laws to really effectively include the reverse mortgage situation, because it is harmful to a lot of Mainers, especially vulnerable Mainers. And I'm delighted that we have this bill before us.
Okay, I just realized I sent him yesterday's link.
Maybe we should do like a little seventh inning stretch right now.
Does that mean you can do time travel, Peggy?
Yes.
Don't
I'm not
bring
sure I'd go back to yesterday.
No, don't bring me back there.
Right.
Peggy, I don't want to distract you. May I, Madam Chair? I wondered if you know if Representative Bailey, what she thought of Mr. Cox's amendments.
She did support his amendment.
Okay, thank you.
Okay, this is silly.
And if I might, Madam Chair, I talked with Senator Bailey today. And
Supi just sent it.
Thank you, Supi.
Thank you, Supi.
Would have done it.
Go ahead, Representative Arnett.
Just wanted the committee to know that I spoke with Senator Bailey today, and she was comfortable with a ought to pass as amended motion with the amendments proposed by Mr. Cox.
Thank you.
Did I say Senator Bailey? I don't know if I did.
So I just want to say, when we were working on the probate code and we needed Professor Smith from the law school to join in to the discussion, she was listening. We didn't have all these Zoom niceties. She was listening, and we told her what the question was, and then she called the committee. So she was on the phone. This is pretty exciting that we can hopefully, if we have a question, the person you want magically appears. Magically, soon.
Magically, with a lot of work by Supi and others, but especially Supi for getting us all through cyberspace and to where we need to be every day. And
Oh, he said he needs a meeting ID to join.
Oh, he's here. He just magically appeared. Oops. Yep.
Ta-da! Yay, Supi.
Welcome.
Thank you.
Thank you.
How can I help?
We have a couple of questions for you about the amendment. I think the initial question was when you were preparing the amendment language, he just magically worked with Senator Bailey. Did you also
Yay, Supi.
did you also check in with any of the other advocates on this topic?
Thank you.
Thank you.
How can I help?
We have a couple of questions for you.
So somebody has their YouTube on.
Somebody has YouTube on. I'm going to mute everybody.
Might be me. Hang on a second.
Wait, it's Mr. Cox.
You have to stay on.
Amendment language. He just magically worked with Senator Bailey. Did you also check in with any of the other advocates on this topic?
It's hard enough living through it all once, but living it through it again is beyond what any of us should have to do.
Deja vu all over again.
I hope I have things shut off properly. I apologize. I spoke in preparing the amendment with the folks who testified on the bill, which was not the main banking industry because they're not covered by this bill. So I did not go to the Maine Bankers Association, the Maine Credit Union. They're not affected by it. So the only folks I spoke to are Attorney DeSalandro, Attorney Randall, and Attorney Selkowitz. I believe they testified, but they were all in support of the bill. And I did run the amendment by Senator Bailey, and we spoke back and forth, and she expressed to me her comfort with it. I can answer one other question that was asked, I think, by Mr. Evangelos. When we initially worked on this bill in 2019, our intent was to cover the entire mortgage servicing industry subject only to the exclusion or the exemption in the final section of the old bill. I did run the amendment button first.
That's okay. Mr. Cox, can I ask you just to, if you could give us kind of a brief description of the circumstance that led you to include the amendment to the bill?
Yes. When a mortgage foreclosure, when you have a homeowner who goes through bankruptcy and receives a Chapter 7 discharge, much of the time the homeowners will keep their house and come out of that bankruptcy keeping the house, but that homeowner's debt will have been discharged. And the servicing statute uses the term obligation. So the obligation to pay the debt personally will be discharged by the bankruptcy, but the homeowner often keeps the house, and sometimes the loan is modified, sometimes the payments are continued, sometimes other remedies are used. But we ran into a case literally over the weekend working with another lawyer where the servicer was sued for entering a house in June for the purpose of winterizing it, which was unnecessary. The servicer was sued under this statute, and the servicer's lawyer has argued that there is no, because the homeowner no longer owes an obligation, the statute should not apply. And so that's why the recommended amendment was proposed to Senator Bailey, to make it clear that the statute will apply even in those situations.
Thank you very much. Committee members, are there any questions for Mr. Cox? Senator Keim, go ahead.
Thank you, Madam Chair. Mr. Cox, I confess to being completely outside of my knowledge base here, but you mentioned that this doesn't apply to Maine bankers. Can you help me understand why?
In 2019, when I'm not sure what your question exactly is. If your question is, how does the statute do that? I can explain that. The final section of 14 MRS section 6113 has a very carefully drafted exclusion provision that we negotiated in 2019 with the Maine Bankers Association, the Maine Credit Union League, to take them outside of the scope of the statute. We were perfectly comfortable doing that because we have no issues with the servicing of mortgages by the Maine institutions. Is that responsive?
Yes, that's helpful, and it helps jog my memory as well. Thank you so much.
Okay.
All right, committee members, we have a motion ought to pass as amended and a second, and we've had an opportunity to ask some clarifying questions to Mr. Cox. Are there any additional questions either for Mr. Cox or for our committee analyst? I am not seeing any. Is the committee ready for the vote? I think we are. Mr. Cox, thank you for zooming through cyberspace. Well, first of all, for being available and listening, and then joining us at the very last minute on our request. We appreciate your help today. Soupy, thank you for taking the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees, excuse me. Representative Libby. Representative Libby is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much. So the motion ought to pass as amended carries with a 12-0 vote. And that closes our work session on LD 1066. And we are going to move on to the work session on LD 737. And I would like to inform committee members that we've been requested by the bill sponsor to provide a little bit more time for negotiations regarding the subject matter of the bill and the exemptions. She is working with other stakeholders to try to bring us an amended bill. Representative Moriarty,
To move to table.
is there a second?
Okay.
Seconded by Representative Harnett. Soupy, I think that we are ready for a vote on the motion to table.
I did not hear this. I apologize. I did not hear the second. I was getting some feedback.
Oh, that's okay. It was Representative Harnett.
Thank you so much. And do you want a roll call or just have the?
We'll do a show of hands on the motion to table. Please raise your hand and keep them up.
Lois, we need well, I'll do it. I'll take it. Senator Keim. I get 10.
Thank you very much. And so the motion to table carries 10-0. And so that concludes our work session on LD 737. And I'm not sure, let me just check one thing. 767, I believe, remained on our schedule for today. But that's something that we had already voted on April 15th. And
Yes,
so,
the sponsor asked for a not to pass.
yep. So we'll move on to LD 853, an act to increase the fees paid to sheriffs and their deputies for service of civil process documents, and open the work session on that. And I'm going to take down my hand because I left it up. Peggy, whenever you're ready, you can.
Thank you. LD 853 is an act to increase the fees paid to sheriffs and their deputies for service of civil process documents. Title 30A, Section 421 establishes fees that sheriffs and their deputies receive unless the sheriffs and deputies are paid a salary instead of the fees. So if they're paid a salary, then the fees are supposed to go to the sheriff's department. So the fees, many of the fees haven't been changed for years and years. And what the bill does is increases it. In some cases doubles, in most cases it doubles the fees from $4 to $8. Actually, if it increases service made in hand from $8 to $40. And these are, anybody can ask the sheriff's office to serve civil process, but the state is a very prolific user of the sheriff's serving process, especially for child support and some child protection activities. So a lot of these costs have, a lot of the rates are increased. I mean, the bill increases almost all of the fees that are currently in the statute. For civil arrests and custody,
it's $60 plus an hourly rate determined by the sheriff to be charged for each hour after the first required for the service, plus mileage that's paid to state employees, which is reiterated in the other sections that would provide for mileage or necessary travel. And the last section of the bill, current law authorizes the county commissioners to add to whatever the fee is in the statute up to $5, except current law says that fee can only be increased by $1 if the state is the one asking for the service of process. So these fees, if they're not paid directly to the deputy or the sheriff, go into the county coffers, and the counties recognize that right now they're paying a higher wage to their employees that are serving this process. So they think this compensates their employees, and it is something that other entities are using the sheriff's office to serve process because it's cheaper for them to do it rather than to find another service to do it, because the sheriff's rates are established by statute. That was a big wandering discussion, sorry.
No, it was terrific. Thank you so much. Representative Harnett.
Thank you very much, Madam Chair. I'd like to make a motion and speak briefly to the motion. The motion is ought to pass on LD 853.
Let's get a second and then you may speak to the motion. Is there a second? Representative Moriarty has seconded. And I also did want to welcome the bill sponsor, Representative Matlack, to our panel this afternoon. And you may proceed, Representative Harnett.
Thank you very much, Madam Chair. Very briefly, as our analyst has pointed out, as did the bill sponsor, these rates have not changed since 1981. One of the largest users of this service is the state of Maine. And to me, this is an unfair shift of the burden to local property taxpayers for a service that is funded at a woefully inadequate level 40 years after it was enacted. I think this is a fair thing to do for both the counties and all property taxpayers, that a portion of their tax is the county tax that is assessed.
Thank you.
So I support the motion.
Thank you, Representative Harnett. Representative Babbage?
Thank you very much, Madam Chair. The last time we had a fee bill a week or two ago, I was disappointed in the cascade that they presented, and it wasn't incremental. The largest increases went to the most common, mostly used area, category. I'm sorry, I just wondered, and there's no doubt that the fees need to be raised, I think, but have we been given any testimony that this is the right amount? Is this in line with other states? Is there a CPI increase from the date of 81 what's the formula? I want to go forward, but I'm asking the question because obviously there's an increased revenue stream that's desired here. I don't think the increase in revenue should by itself drive our decision to determine what that revenue should be. That's all. But I wondered if we'd received any testimony to tell us that these fees are in line with what they should be. If there was any justification for that. Thanks.
Is that a question for Peggy?
Yes.
I don't have that information, and I did not look at what other states charge or allow to be charged.
I did not ask you to, but I
Okay.
wanted to know if others knew more than I did about this.
Representative Babbage, let's check in with the bill sponsor and see if she has additional information. Representative Matlack, do you know what the source is of the specific dollar amounts that are included in the bill?
Not specifically. I work with my local sheriff in coming up with these numbers. They were based on his calculation of what actual costs are for the deputies to do the civil process. At one point, he did do a calculation, what if there had been incremental increases over the years from 1981 forward, and the cost of one of these services would be well over $30. So this is trying to bring the actual cost of fees. I mean, even looking at the dollars, you can understand that they do not in any way, shape, or form reflect what it currently costs to do this work. And so to bring them in line, I'm not sure why this was not requested more in a more timely manner going forward. I'm hoping that they will do this on a more regular basis so that it doesn't become so out of line. But it was an opportunity to ask that the services that they're being asked by the state to provide are properly paid for, rather than falling to the taxpayers of the different counties.
Thank you, Representative.
You're welcome.
Thank you for explaining that, Representative Matlack. Committee members, are there other questions regarding LD 853? I am not hearing any, and we have an ought to pass motion that has been seconded. Is the committee ready for the vote? It appears we are ready for the vote, and Supi, thank you very much for appearing on our screen.
Happy to be here. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
I would vote yes, but I would like to add an amendment to it later on with maybe Peggy's help. Did none of that go through?
Oh, no, we heard you were just stunned. I think that what you need to vote is ought not to, I think this is the vote on the bill. So if you want to add an amendment,
All right.
you might want to vote ought not to pass.
Okay,
and
then
then
I'll just do
have
that.
an ought to pass as amended. I don't know. I don't want to put words
Sorry,
in the chair's mouth.
Been a long day.
No,
Ought not to pass, that's fine.
Yes.
No, the motion is ought to pass.
Yeah.
If he wants ought to pass as amended, he would vote no.
Okay, thank you.
And then you can say you want an ought to pass.
Okay, thank you very much. I've never done that.
I'll repeat.
No.
Representative Hagan votes no. Representative Libby. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne. Representative Evangelos. Representative Newell. I will recall the absentees. Senator Keim. Senator Keim is absent. Representative Libby. Representative Libby is absent. Representative Thorne.
I'm sorry, I got knocked off. We got a thunder and lightning storm going on, and I don't know where we are and what we're doing.
We are voting on LD 853. There is The motion is ought to pass. And it appears that Representative Hagan is going to provide a minority report, which is an ought to pass as amended.
So I missed the vote, huh?
No.
We're right in.
Actually, sorry. Would you like me to recall your name, Representative Thorne?
Yes, please.
Okay. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell. Madam Chair, I have 7 members voting in the affirmative, 3 members voting in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much. And Representative Hagan, could you please provide us with your report on the bill?
I'm not sure how I want to amend it. I've got all kinds of thoughts, and I was curious if I could bend Peggy's ear on Monday on that.
You're welcome to bend my ear on Monday. That's fine. If that's
Just to make
okay
sure that my amendment doesn't violate anything.
That's fine. I know that the committee rules require some sort of explanation of what the minority report is.
Okay, it'd be ought to pass as amended, and I'm thinking a little less in the monetary.
Representative Poirier and Representative Thorne, are you on the same report or a separate report?
Same.
Okay.
Same.
Thank you very much.
Thank you, everybody.
Thank you.
Thank you very much.
Thanks, Representative Matlack. And so the motion ought to pass carries with 7 in favor. There's an ought to pass as amended that received 3 votes. There are 4 absences. And with that, we close the work session on LD 853. And is everybody ready to move forward with our last 2 bills? Does anybody, Peggy or Soupy, do you need a break before we forge ahead?
No, thank you.
Thank you.
Committee members, everybody else set? Looks like it, okay. So we'll open the work session on LD 1160, an act to reduce the burden of courts and promote the resolution of civil cases. Peggy, do you want to go ahead just with a brief analysis on this one?
Sure, very brief. So section 1 of the bill changes the pre-judgment interest rate. So when you file a case and before you get to judgment, there is interest that can accrue. And this changes it from 3% to 12%. Post-judgment interest, after you have a judgment and before it's paid off, there's interest that accrues. And this would change it from 6% to 12%. Section 3 of the bill amends the, what's it called? The unlawful claims practices, unfair claims settlement practices in the insurance code to extend the options for coverage to any third, right now it applies when an insured is injured by actions taken by their insurance company. This would apply to a third party liability insurer as well, would be responsible. And both the insured and the person who is going to benefit from that insurance can bring a civil action directly against the insurer. And for a violation of the unfair claim settlement practices, section 4 would allow the court to award triple damages against any insurer that violates that. And then section 5 amends the law that allows, it would prohibit subrogation when an insured's award or settled damages exceed 20,000. I'm sorry, it would allow subrogation when an insured's awarded or settled damages exceed $20,000. Right now, so this would prohibit subrogation. The insurance company would not be able to collect the payment to the insured if the insurance company has already paid for medical costs, for example, if the award is 20,000 or under. I know that was fast, and I know there's an amendment that has been proposed.
Thank you very much, Peggy. And Representative Harnett, did you want to speak briefly to the the amendment? And then I will also let committee members know that what I'm thinking we should do with this is to hear a description of the amendment, but then table the bill until we have the amendment language ahead in front of us that we can really take some time to look at before voting on.
Thank you, Madam Chair. And Peggy, correct me if I'm wrong. I'm going to run through what I believe the amendment does. And if you could correct me if I'm getting that wrong. In section 1, it changes the pre-judgment interest rate from 12% down to 10%. In section 2, it does the same for post-judgment interest from 12% down to 10%. Section 3, as I read it, by eliminating the language that had been proposed, it brings the statute back to its original form,
Right.
that is now current law.
So I think section 3 would just come out entirely.
Correct. And section 4, which dealt with treble damages, has been removed entirely. And subrogation, the section 5 dealing with subrogation remains the same as in the original bill.
Yes.
Those are the changes. I know some of those changes addressed some of the concerns raised by opponents to the bill. But I know that we did have testimony provided by the Department of Insurance regarding some of the sections that have been amended, and one of the sections that has not, being the one on subrogation. So I understand the need to table it to hear from that interested party, and for the committee members to have the opportunity to fully digest the amendments and work the bill at a later date.
Is there any discussion that people would like to have before we move forward with a motion to table? I am not seeing any discussion. And so Representative Moriarty?
Madam Chair, I move to table.
Thank you. Is there a second? Seconded by Representative Sheehan. And committee members, if we can all again just activate our raise hand functions in order to indicate our votes on the motion to table.
I don't think Representative Reckitt has a raise hand function on her phone.
Right, that's my problem. But I'm also off the table in the physical therapist, so that's good. I'm in the car now, but I'm not driving. I'm just sitting in the parking lot. Lest you report me to the state police.
I have 10-4.
Yeah,
Or absent.
I believe so. I'm not sure. I didn't see
I only have 9.
Thorne's hand.
Well, I have 4 absent, so that means 10 have to be voting. Representative.
Well, I don't have Representative. I don't see Representative Thorne's hand.
Yes, there it is.
Okay, great.
All right.
Thank you. So 10-4.
10-0 for absent.
0.
Thank you, everyone. And with that, we have tabled 1160 10-0, and close the work session on that bill. And we are in the home stretch, everybody. We're opening our very last work session of the day on LD 1236. This is an act authorizing the Attorney General to enter into contingent fee agreements. And Peggy, if you would like to give us your bill analysis.
Sure. So this bill does exactly what the title says. It allows the Attorney General to employ private counsel, and then if the state wins some sort of judgment or settlement, that the attorneys that have been under contract can be paid out of that, out of the proceeds of that settlement or that award. They cannot do that now. Current law does not allow any deduction of settlements or awards.
Thank you very much, Peggy. It's good to end on a very plain and simple note. So I'm the bill sponsor, and I will just briefly state that I think that this is an important bill because it allows Maine to engage in litigation, including things like product liability claims against the manufacturers who are responsible for the PFAS contamination that has impacted communities throughout our state. The Attorney General is here, and if people had follow-up questions to ask him, we can bring him onto the panel. So let's start with Representative Reckitt. Your hand is raised.
Yes, I found it. I would like to make a motion and then speak to it. I heard Representative Harnett do that, so I know it's legal. Anyway, I'd like to move ought to pass. And I'd like to say briefly that I think there is going to be a continuing chance for the state to engage in proactive legislation that could also not only be important, but could also bring funds to the state and to the people in need. So I'm very anxious for this to be enacted, and hope that others will join me.
Thank you very much, Representative Reckitt. Do we have a second on the motion?
Second.
Seconded by Representative Harnett. Committee members, is there discussion on the motion? Not seeing any discussion, or is the committee ready for a vote? It appears we are. Okay. Thank you very much, Supi.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell. I'll recall the absentees. Representative Moriarty. Representative Moriarty is absent. Representative Libby. Representative Libby is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 6 members voting in the affirmative, 4 members voting in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. For those who voted against the motion, what is your report?
Ought not to pass. Thank you.
Thank you. And so the motion carries 6-4 with 4 absences. And with that, our work session on 1236 is concluded. And I believe that we have finished our work for the day. Thank you, everyone, for all of your hard work today. Yeah, a round of applause. We did good today. Thank you, everyone, and looking forward to seeing you tomorrow morning at 9.
And Madam Chair, I just let you know, I am getting my shot tomorrow, so I'll join you when I get home from that.
All right, I hope it goes smoothly.
Great.
Good night, everyone.
Good night.